This is a special hearing, and today's subject matter is officer body-worn cameras. It should be noted that this past spring session we engaged in negotiations which are ongoing with regards to our state's eavesdropping law, which was stricken by the courts. And one of the topics that arose in the spring, in the late spring, was a question of body-worn cameras. And this was before a lot of hyper-focus on the topic as a result of various events throughout the country. So I'm glad everybody is here. I want to yield to Co-Chair Nekritz for opening comments.
Thank you, Senator. I just would like to add, I think our goal here today is really to start to continue this dialogue and really dwell down into some of the details and to then help clarify the intersection between what, on the body-worn cameras, what the state's role is in setting policy on this, what the local agency's role is, and how we can protect citizens' privacy. We have there's a whole long list of questions I think we want to drill down on today. So I'm looking forward to the testimony.
All right. Our first witness today is going to be Lindsay Miller, a research associate from Police Executive Research Forum. I'm going to give a special thanks to Sean Smoot for securing this witness for us.
Let's see, is this working? Okay. Good morning, and thank you for the opportunity to speak here today about the use of body cameras by law enforcement agencies. My name is Lindsay Miller, and I'm a research associate at the Police Executive Research Forum, which is an independent research organization located in Washington, D.C. We have over 2,000 members at PERF who include police officials, academics, federal government leaders, and others with an interest in policing and criminal justice issues. Last year, PERF was approached by the U.S. Department of Justice's Office of Community Policing Services to examine one of the most critical issues facing policing today, and that's the use of body cameras. Although there's been an increased focus in body cameras in the wake of high-profile incidents like those in Ferguson, really this technology has been on the rise for the past several years. Smaller and mid-sized departments were among the first to adopt the technology, and then over the past year, departments in some of the country's largest agencies, such as Los Angeles, Washington, D.C., New York, not New York, New Orleans, and Houston have also started implementing pilot programs. So like any new technology, body cameras raise a number of difficult questions. Some of these questions involve larger policy issues, such as what is the impact that body cameras have on public privacy? What effects do they have on relationships between police and the community? And of course, what expectations do they raise in terms of police accountability and transparency? And in addition to these larger questions, they also raise many practical questions that agencies have to consider, such as when do officers turn their cameras on? How long do agencies retain the video, and when do they have to release those videos to the public? And also, agencies have to figure out a way to mitigate some of the enormous costs that camera programs present. So as we spoke with police executives across the country, we found that they were seeking guidance on these and other difficult questions. This technology is so new. So many agencies told us, we want to implement a body camera program, but we just don't know what policies to use and what practices to do, and there's just not much guidance on it. So that was the goal of our research, to explore some of these issues and then to provide practical policy guidance to the agencies that want to deploy this technology. So before I get into the details of our findings, I'll provide just a little bit of background on our project. Our research consisted of 3 key components. PERF distributed an informal survey to 500 police agencies across the country to gauge just kind of the existing use of body cameras and what some of the policies and practices are. We received responses from 254 agencies, and their answers were kind of a starting point to guide our research. And then we also conducted field research that involved interviews with more than 40 police officials and other experts about their experiences with body cameras. And we reviewed more than 20 written policies that were submitted by agencies across the country. And then last September, in 2013, PERF and the COPS office convened a conference in Washington, D.C. that was attended by more than 200 police chiefs, sheriffs, federal justice representatives, and other experts, where participants came together and discussed some of these issues and how their agencies had dealt with them and just their experiences with body cameras. So drawing from all of this research, last month we released a publication titled Implementing a Body-Worn Camera Program, Recommendations and Lessons Learned. The report consists of 3 major parts. 1 is a discussion of the benefits that body cameras have. 2 is just a look at some of those larger policy considerations that I mentioned. And then we also provided a set of 33 very specific guidelines and policy recommendations for law enforcement agencies to use. So before getting into those, I just want to say that first and foremost, PERF believes that the decision to implement a body camera program should not be entered into lightly. Once you go down that road, it's really, really hard to reverse course or to scale back your program, and the public's going to come to expect that these videos exist. So this is why it's so important that agencies thoughtfully examine all of the issues that body cameras have, not just jump into them, and develop carefully crafted written policies that govern their use. So today I'm going to discuss some of our findings and then highlight just a few of our key policy recommendations. And to start, I'd like to share some of the reported benefits of body cameras that were told to us by police executives and other experts. We found that there's an overall perception that body cameras serve as a useful tool, not only for law enforcement agencies, but for the community as a whole. In fact, the use of body cameras has been embraced not only by police agencies, but by civil liberties groups such as the ACLU, by advocates for fairer policing, and by local community organizations. Although these groups may disagree on specific policy points, they generally agree that body cameras have the ability to improve policing. So the first reported benefit is that body cameras can help strengthen police accountability and transparency. The police executives that we consulted realized that there's an increasing public demand for police accountability and for police agencies to be open about their activities. They know that the prevalence of camera phones and social media means that their actions are no longer, are no longer hidden from the public, and that really it's in their best interest to be as transparent as possible. And for the most part, the police executives that we spoke with feel that the majority of their officers are good, hardworking people, and they want the chance to demonstrate that. And when an officer does engage in misconduct or when there is a problem, they want the chance to address the community's concerns and to answer their questions and to show that they are taking corrective action when it's necessary. A second reported benefit is that cameras can help prevent and de-escalate confrontational situations between officers and the public. Time and again, police executives told us that the mere presence of a camera can help strengthen both the professionalism of the officer and the behavior of the person being recorded. Because of this, we heard over and over that deploying body cameras has led to fewer citizen complaints and fewer officer use of force incidents. And although there haven't been that many rigorous studies yet on the impact of body cameras, the ones that do exist seem to back this up. In 2012, there's a now sort of famous study in Rialto, California, that showed that there was a 60% reduction in the officer use of force incidents following camera deployment, and that shifts without cameras experienced twice as many use of force incidents as the shifts with cameras. The study also found that there was an 88% reduction in the number of citizen complaints after cameras were deployed. And a similar recent study in Mesa, Arizona, found that officers who wore cameras experienced 75% fewer use of force complaints and 3 times fewer overall complaints than officers without cameras. So this ability of body cameras to help prevent and defuse confrontational situations is why many agencies actually encourage or require officers to announce when they are recording. As one police chief told us, we actually encourage our officers to let people know they have the cameras on. Why? Because it elevates behavior on both sides. So a third reported benefit is that body cameras can help lead to a quicker resolutions when complaints and incidents do occur. The footage provides an accurate record of events, or a more accurate record of events, for courts, oversight bodies, and internal affairs units to review. And they can also help prevent unfounded complaints from being filed in the first place. This quicker resolution can help save agencies time and money that they would otherwise be spending defending lawsuits and investigating complaints, and it can also help resolve tensions and concerns among the community when a controversial incident occurs. Another reported benefit is that cameras can help strengthen officer agency and performance overall. 94% of our survey respondents said that they use cameras to help with training and administrative reviews. And at the individual officer level, agencies are using cameras to train officers on proper protocols and to, of course, identify when officers are engaging in misconduct or violating policy. And now at the larger agency level, cameras are helping management identify and address larger structural problems that exist within the department. And this can help them identify policies and practices that need revising or areas where more training is needed overall. For example, the Greenville, North Carolina Police Department used body cameras to address concerns that certain officers were engaging in racial profiling during traffic stops. So the supervisors reviewed the body camera footage, and they did find that there was a pattern of officers using flimsy probable cause when they were pulling over motorists. So the department determined that it was a training problem, and they revised their training protocols, and this was effective in helping to address the problem. So this aspect of body cameras is why the federal government is increasingly requiring agencies under consent decree to deploy cameras as a remedy. And these cameras are helping these agencies that are under investigation to demonstrate that they are engaging in constitutional policing. And finally, police executives report that body cameras have helped them to improve evidence documentation for investigations and prosecutions. They're using cameras to record interrogations and arrests, to capture what officers witness at crime scenes, and to document statements made by victims and witnesses who are willing to speak on camera. And this can be particularly useful in cases that are notoriously difficult to prosecute, such as domestic violence cases. For example, prosecutors in Daytona Beach, Florida, encouraged the police department to use body cameras to capture more reliable evidence of domestic violence cases. With the victim's consent, officers can record the victim's statement that show firsthand the victim's injuries, demeanor, and reactions. And if they arrive at the scene while the incident is ongoing, they can even capture the assault itself on video. And this means they can move forward with the case even if the victim declines to prosecute. So having described some of the reported benefits of body cameras, I will now discuss some of the larger policy considerations that these cameras raise. And when developing their programs, agencies must carefully examine these policies and practices, their policies and practices, and how they intersect with some of these larger considerations. One of the most significant considerations is the impact that body cameras have on the public's privacy rights. The notion of privacy has obviously evolved in recent years with the proliferation of camera phones, social media, CCTV, YouTube, things like that. In this day and age, it can often seem like everybody is filming everyone else. So there are some serious questions about how police body cameras fit into this new notion of privacy. Everyone may be filming everyone else, but is it okay for the police to be filming you too? And body cameras are different from traditional surveillance cameras, which are typically fixed in one place and located in public areas. But body cameras can record both audio and video. They can capture close-up images of people's faces, and they go wherever the officer goes, including into places that are traditionally private, such as inside a person's home. And because body camera footage is subject to public disclosure, people worry that images that are captured of them while they're in their most vulnerable will be released for the world to see. They ask things like, if the police come to my house wearing body cameras, will my neighbor be able to request the video and see what was going on inside? Or if I'm a victim of a crime, will my statement to police end up on YouTube? So because of this, agencies have to think carefully about the impact that their camera policies will have on privacy. Even decisions that might at first seem to be technical, such as when to activate the camera or how long to keep the videos, will have serious implications on privacy. When making these decisions, agencies must balance these considerations with the need for transparency of police operations and the accurate documentation of evidence. A second large policy consideration is the impact that body cameras have on relationships between the police and members of the community. The success of a police department and the legitimacy that that department has in the eyes of the community depends in a large part on whether it can build trust, openness, and good relationship with the people that they serve. Many police executives fear that excessive recording will have a chilling effect on these important relationships. A detective from Baltimore told us, "The comments I hear from some officers are, I'm worried that if I wear a camera, it's going to make it hard to continue the relationship I have with the business owner or the lady down the street. These are the people I'm working with now to clean up the neighborhood." Some police executives also fear that members of the community may be more reluctant to come forward to share information about a crime or problems in their neighborhood if they know that they are being filmed. And this can undermine community policing efforts and make it more difficult for officers to proactively address crime and disorder. A third policy consideration is the impact that body cameras have on relationships and trust within the police agency itself. One of the biggest concerns reported by officers is that by requiring them to wear cameras, they feel that management is essentially saying to them, we don't trust you to do your jobs correctly. And this can undermine trust within the department, especially if officers believe that their supervisors are using cameras as a sort of gotcha tool to catch them violating policies and to track their every move. Police executives told us many different strategies that they use to alleviate these fears, including engaging officers in the decision-making process, educating them on the expectations and benefits surrounding cameras, and stressing to officers that cameras are a useful tool that can make their jobs easier. They have also found that once officers start wearing cameras, they almost always see the benefits to having them. As Chief William Farrar in Rialto told us, now that my officers wear the cameras, they say they could not do without them. And that is the refrain that we heard time and again. A fourth consideration involves the expectations that body cameras create among courts, oversight boards, and the public. Many executives told us that it's becoming increasingly uncommon for these groups to expect not only that officers wear cameras, but that the cameras capture every single thing that happens while an officer is on duty. This expectation can be unrealistic because agency policy may preclude recording in some circumstances, or it may be unsafe or impossible for an officer to record. This is why many agencies have taken steps to educate courts, oversight bodies, and the public on the reality of using cameras and what they can and cannot do. And it's also important why is it important to create accountability mechanisms to ensure that officers are complying with the program. As the police chief in Topeka, Kansas told us, it isn't the videos that you have that cause the problems. It's the videos that you don't have but you're supposed to have that cause the problems. And finally, police agencies must also consider the significant costs that body cameras present, both in terms of money and human resources. Most of the agencies we consulted spent between $800 and $1,200 for each device, but the bulk of the financial costs is in data storage. For example, the New Orleans Police Department estimates that it will pay $2 million per year to outfit 900 officers with cameras, and most of that goes to data storage. In addition to these costs, the agencies must also pay for ongoing training and camera maintenance and program management. Many agencies have one full-time person whose sole job it is to manage the camera program. And as the public becomes increasingly aware of cameras, there's inevitably going to be more and more requests for videos from the agencies. So they're going to have to devote a lot of time and money to reviewing the videos, redacting the videos, and preparing them for public release. Now that being said, most of the police executives that we consulted said that the cameras are worth these considerable costs because they save them money in investigating complaints and defending lawsuits. This is why we recommend that, if possible, agencies conduct a cost-benefit analysis before implementing a program. And we also heard several useful suggestions for how to mitigate the costs of a camera program. For example, the Los Angeles Police Department worked with its local police foundation to raise money from private donors, and this strategy has also been successful in smaller places like Greensboro, North Carolina. So having discussed the benefits and the considerations, I'm now going to turn to our policy recommendations, which are based on the promising practices and lessons learned that emerged from our research. When considering these recommendations, we caution two things. One is that every agency is different, and so each department must adapt these recommendations to fit its own needs, resources, legal requirements, and policing philosophies. And two, when developing their body camera policies, we recommend that agencies consult with frontline officers, local unions, legal advisors, prosecutors, community groups, local policymakers, and the general public. Incorporating input from these groups will help improve the legitimacy of the program and make implementation go much more smoothly. And agencies should also make their body camera policies available to the public. So in our report, we set forth 33 policy recommendations, but for today's discussion, I'm only going to highlight a few of the ones that come up time and again and that we think are the most key. So probably the biggest policy decision that an agency has to make is determining when officers will be required to activate their cameras. Some experts advocate for recording all encounters between an officer and the public, but PERF believes that this approach is too broad. Instead, we recommend that with limited exceptions, officers should be required to activate their cameras when responding to all calls for service and during all law enforcement-related activities and encounters that occur while the officer is on duty. This is the most common approach adopted by police agencies that we consulted. And the rationale for this is that it gives officers some discretion about when to record the types of casual, non-law enforcement related conversations that I discussed earlier. By and large, agencies find it problematic to tell officers that they have to turn their cameras on, for example, when they're discussing the football game with the shop owner that they see every day, or when they are chatting with an elderly lady about her grandkids. They don't want every conversation with the members of the community to become formalized, and they don't want to make people uncomfortable being open and honest or worried about their privacy. That being said, any discretion that officers have should be limited and guided. Policy should clearly define what constitutes a call for service or a law enforcement related activity or encounter, and this definition should be reinforced through rigorous training. Some of the activities that are included in this definition typically are arrests, interrogations, pursuits, searches, traffic stops, visits to live crime scenes, and encounters that become confrontational after the initial contact. We also outline certain exceptions to our general recording recommendation. One is that officers should not be required to activate their cameras when doing so would be unsafe, impossible, or impractical. Another exception is that officers should be required to obtain consent prior to recording conversations with crime victims. And the rationale behind this is that, of course, there are significant privacy concerns with taping a person who has just been a victim of a crime. And a third exception is that officers should have the discretion to keep their cameras turned off when they are interviewing crime witnesses or people who have come forward to share information about a crime. Many people who are in this situation are hesitant to speak on camera out of fear of retaliation or out of their own concerns about their own privacy. And if that's the case, officers should be allowed to take the statement off camera or to switch the camera around so that it only captures audio and not video. Of course, these statements have great evidentiary value, and so we recommend that if possible, officers make every attempt to record them. But if the person is unwilling to speak on camera, we believe that the officer should have the discretion to comply with that person's request. And again, any recording discretion that an officer has should be guided and limited. Agencies should create mechanisms for holding officers accountable for their recording decisions. For example, one of the most common ones we saw was requiring officers to state either on camera or in writing why they turned the camera off and when they did it. So if someone comes up and the officer's interviewing them, they would say, "I'm now turning the camera off because the witness does not want to be filmed." And this helps, management and supervisors understand why there's missing video, and it creates accountability for that officer. We also say that when in doubt, officers should always record. PERF also recommends that officers should be required to inform subjects when they are being recorded. And this is based, again, on reports that officers and the public tend to behave better when they know that there is a camera running. Now, it's important to note that informing a person they are being recorded is not the same as obtaining that person's consent. So in addition to these recording policies, our recommendations also provide guidance on how long agencies should retain body camera videos. And again, this has significant implications in terms of privacy because the longer the videos are around, the more likely it is that they can be released or accessed by the public. So typically videos are broken down into two categories. One category is evidentiary footage, which contains evidence that can be used in an investigation or a prosecution or administrative review. And the other category is non-evidentiary footage, which does not contain evidence or just contains footage of a non-confrontational routine encounter. Evidentiary videos are typically governed by evidentiary laws, and so the retention times will be dictated that way. So if you have footage of a homicide, then typically the law would make you keep that indefinitely. But there is more leeway in setting retention times for these non-evidentiary videos, and that's where a lot of the debate comes in. The most common retention time that we saw for non-evidentiary videos was between 60 and 90 days. And when making this determination, agencies take into account how long it typically takes for people to file complaints, the state's public disclosure laws and how open they are, the agency's data storage capacity and costs, and the department policies governing other types of electronic records. And we recommend that in all cases, when setting retention times, agencies should consult with legal counsel. And they should also make these retention times available to the public so that they are aware of the window in which they can view the footage. We also made recommendations about data storage, which I won't get into here because it is very technical, but The bottom line is that agencies need to make sure that they have strong mechanisms in place for protecting the integrity and the security of the data. Most agencies typically store videos either on an in-house server, which is managed internally, or an online cloud database, which is managed by a third-party vendor. And we don't recommend one storage method over another, but we just say either way, you need to have audit trails. You need to know who's accessing the data and why. And you need to have ability to prohibit data tampering or deleting or copying videos. One of the biggest issues that we're seeing recently is when should agencies release body-worn camera footage to the public and the news media? So first and foremost, agency policies must comply with the state's public disclosure laws. PERF generally recommends a broad disclosure policy because it's our belief that by making the decision to deploy cameras, agencies are signaling to the public that they are willing to be transparent and to hold officers accountable for their actions. That being said, before deciding whether to release the footage, agencies must also take into account privacy considerations and the needs of further investigations and prosecutions. Most public disclosure laws have an exemption for evidence that's being used in an investigation, and this will also apply to body camera footage. And the most important thing is for agencies to have clear and consistent policies regarding public disclosure. We also make recommendations about training, which is a key part of any body camera program. We recommend that it be rigorous, ongoing, and required for all agency personnel who may be involved with body cameras. And we found that a lot of agencies have also found it useful to do scenario-based training using model cameras because that helps officers just consider turning the cameras on as being second nature. And finally, we recommend that agencies conduct regular evaluations of their body camera programs. They should collect statistical data concerning body camera usage and regularly make this data available to the public. They should periodically review their programs to assess the effectiveness, financial impact, and legal compliance. And they should also evaluate how the program is affecting the community. One agency that we consulted conducted citizen surveys to determine how the cameras were being received in the community and what the public thinks of them. And again, we have many more recommendations in terms of access and storage and all sorts of things. They're located in the report, which I believe you all have a copy of. And if not, I've got some extra copies. Okay. So in conclusion, our research found that when implemented correctly, body-worn cameras can provide real benefits that help improve the policing profession. However, they also raise numerous practical and policy questions for agencies to consider. Above all else, police agencies that are considering deploying cameras must make careful, thoughtful decisions about how this technology will be used. They must have clear and consistent policies and strive to minimize any harmful effects that cameras may have on privacy, public trust, and relationships within the agency and the community as a whole. So I'd like to thank you all again for the opportunity to speak today, and I would be pleased to answer any questions.
All right. First, let's add Senator Harmon, Senator Mulrow, Representative Turner, Representative Tipetti to the roll. I've got a couple of questions, and reps and senators, please signal to Ashley here that, if you'd like to ask a question.
Before we do that, though, we obviously have a lot of legislators here, so I think that Senator Raoul and I are going to have to be a little bit arbitrary in cutting things off because we have a lot of witnesses to get to, so I just want to let you know, don't take it personally.
Yeah, and I'm going to let Representative Neckritz, Chairman Neckritz, let down the axe on you, including me. So you offered us some of your recommendations, amongst many that seem to be largely directed towards the agencies, at the agency level.
Yes.
What we are contemplating here as a legislature is what kind of framework we set at the state level. Do you have any recommendations with regards to that?
Well, I think that our recommendations are definitely at the agency level, but I think that we do believe that the agencies have to have some leeway in setting their own policies just because they're so different in terms of the resources they have, the communities that they serve, and things like that. And At the state level, I think that the legal framework is important so that agencies know what legal requirements they're going to have to comply with. I think that the general principles in terms of why agencies are adopting cameras and how they can be used, I think that's an important thing for the state level to address. I think when it comes to individual things like how long should you keep your data, I think that's a difficult thing to dictate in terms of, because some places just may not be able to afford to keep data as long as others. Cities like Chicago would produce a lot more videos than smaller towns. So I think that some of the general principles, that's the most important thing from a higher level perspective.
Are there any states that have a policy with regards to body-worn cameras that you think is somewhat of a model policy?
You know, I actually did not encounter any during my research. I don't know if that's because there's not many that exist or because that's not really what we were focusing on as much. Our members are largely police organizations, agencies, so we focused on gathering information from them and their policies. And I think there's just not a lot of policy out there. I think there's more now, but when we started this last year, it was really hard to find, hardly any policies. So I wish I could be more helpful on that, but I did not encounter anything of that sort.
And with regards to, you mentioned informing folks that they're being recorded. Is there any limitation upon that? I mean, so officer in pursuit,
yeah.
You say, hey, stop. By the way, I got
yeah.
my body
No,
camera.
Absolutely. In our recommendations, we say that should be a requirement unless doing so would be unsafe, impossible, or impractical. And for just the reasons you described. Sometimes it's just, they just can't. They just don't have the time. It's unsafe. So we definitely would provide that sort of exception.
And digging a little deeper into unsafe, impossible, or impractical. Those are fairly broad terms.
Sure.
Can you kind of?
I think I think that we don't define them really in our recommendations. I think that's another area where the importance is having the accountability mechanisms so that an officer can't just say, oh, it was impossible to turn it on. I think they have to provide a rationale on camera or in writing why they didn't turn it on, why they turned their camera off, why they didn't notify the person if that's an issue. And I think that accountability mechanism is the key. And I think it's up to the agencies to define what those are. And again, we didn't really get into I think it's such a situational thing that it would be hard to capture all the different times when it might be unsafe or impossible. But I think the key is to have the strong accountability mechanisms. So,
and this is my last question, and I'll yield to other members. And I understand that different departments deal with different circumstances, whether they're economic or otherwise, whether they're in a dense municipality or less populated municipality, that would lead to varying policies. Would you advise any sort of, notwithstanding that, would you advise any sort of, if not in the law specifically, any sort of recommended guidelines to policy implementation at the agency level?
You mean in terms of specific recommendations or just how policies are devised? Guidelines
that aren't mandated policy, but just that guideline.
Yeah.
So
yeah, I mean, I think that, well, I mean, the recommendations that we put forth, we would say that those would be mandated policies by the agency policy, not necessarily law. But I think that some of them are universal. Some of them aren't just, like I said, some like the data retention and storage are going to be dependent on the agency, but others, such as when to activate the cameras, we think that those are more universal, and those should be applied to every agency should adopt those recommendations. But So yes, we do have
you wouldn't
some.
suggest a statewide data retention policy?
I would not. I don't believe that we would, no, just because, now obviously, like I said, for the evidentiary videos, things that, you know, videos that contain evidence of a homicide or an assault or a complaint,
Yeah.
those are going to be governed by the state, the evidentiary laws and regulations. But for, you know, if an officer has his camera running and he's assisting a motorist and then he goes about his way, for those, you know, we've seen varying retention times for those, and that's where I think it does depend on the agency's data capacity, data storage capacity, the costs that it is going to be, the number of videos they produce. So I think a statewide retention policy would be a little difficult for that reason.
Okay. Chairman Neckrits.
Thank you, Chairman. I just have one follow-up on the accountability.
Mm-hmm.
Are there ways to do audits of other agencies? Have agencies done audits on, so that if you can catch an officer who routinely, you know, does something and that you want to put an end to?
Absolutely, a couple of ways. Some of the camera systems, and I think there's a technical panel later that they'll probably be able to talk more about this, but some of the camera systems have built-in audit trails that show who's accessing the data and when. But then there's also forensic reviews can be done, and I think that the ability of forensic reviews to uncover things is getting better and better, the technical ability. We had, I think it was Daytona Beach, the police chief told us a story of an officer who went out with his camera on, and then a person came in to file a complaint against the officer later and said that he had been rough with her when he was arresting her. So they went back to look at the footage, but the footage was missing. So he claimed the camera malfunctioned, and they said, okay, well, we'll give you another camera. Don't let it happen again, you know. And then the same thing happened again, like a week later. And so that's when they said, all right, clearly this is more than a camera malfunction. So they sent the footage off to, the camera and the footage off to the vendor, and they were able to determine that it was not a malfunction, that the officer did in fact turn the, you know, physically deactivate the camera, and the officer resigned once. So those things are being
And
done.
is there a way to do that? I mean, so that's the result of a complaint. What you don't know is if there's no complaint, then there's no.
Right.
Are there ways to, or should I ask the technical panel?
Yeah, no, I think that one of the things that we talk about in our report is kind of supervisor and management review of the footage. And supervisors, you know, we recommend that supervisors always conduct incident-based reviews, which would be a situation like that when there's a complaint. But we also recommend that an agency's internal audit unit conduct random monitoring of body camera footage to see, one, if officers are complying with the program, and two, how officers are performing overall. We kind of divide that because we think the internal audit unit, rather than the person's direct supervisor, should do that random monitoring, because we heard that that really can affect trust within the department if the officer thinks that their supervisor is going to just be sitting in a room going through all their footage for no reason. So, but we do recommend that an audit unit do that, and it is possible to do that. Yes.
Very good. Thank you.
Mm-hmm.
Got Senator Nolan and then Representative Anthony.
Thank you, Chairpersons Neckrits and Raul. Thank you, Ms. Miller, for what seems to be very thoughtful, very thorough coverage of this issue. We've had some time to consider body cameras in the legislature. We've been doing so for the last couple of years, quite frankly. But we obviously haven't had this piqued interest as we do now for reasons that I think we're all familiar with. Let me ask you something, couple of brief questions, okay? With regard to what we can do at the state to perhaps incentivize or to perhaps direct either local law enforcement or the courts, for example, to adopt certain policies with regard to this type of evidence that's gathered. Have you had an opportunity to consider, it's a new term, it's a relatively new term, I don't expect a lot of people to be familiar with it, but this term known as the missing video presumption. Have you had a chance to think about that? Are you familiar with that term? I'll be glad to explain it.
Yeah, I don't know that I'm familiar. You might clarify just exactly what that would refer to.
So if in an instance where a police officer is required, or it is the agency's policy to have the video running, as it were, that when it comes down to a dispute as between a defendant or an accused and the proponent of the evidence, the agency, that the court, the state's attorney, would have to accept that there is a presumption in favor of the defendant or the accused.
If the video is missing.
Yeah, and it should be there. It addresses, I think, the question that you, or the problem that you identified before. When were we supposed to have video, but we don't? Right.
I mean, the legal aspect of it, especially with regard to the courts, was a little outside of what we did with our report, just because, again, we were gearing it more towards recommendations for the agencies to use as they were implementing camera programs. I think that agencies are well aware that that sort of a presumption, whether it's official or not, exists now, and I think that there's a lot of officers feel that their credibility is on the line if that video is missing, and I think a lot of the police executives feel that it is a big issue. We did hear that quite a bit, and I think that is why they are strongly encouraging or requiring officers to record in those circumstances, why they have them say on camera, I am now turning my camera off because this witness told me to turn it off, or I put in their report, I did not activate my camera because I was pursuing a subject, just these accountability mechanisms, I think, especially if you're taking the policy of not recording every single encounter between the public and the officer, I think those accountability mechanisms are very important, and that's the reason why. And again, I don't want to give any personal or opinions on a presumption like that, but I can see where it is becoming an increasing problem, or not problem, but issue for the agencies have to consider, because more and more people just assume that they're going to have the camera.
It might become more widely accepted.
Yeah,
I think so. Okay.
I think absolutely.
Good. Then the other question I have is regarding the retention of this evidence or the video. What do you say to the notion, what does PERF say to the notion of a third party, an authorized third party, not just anyone, but just a statewide sanctioned third party to retain this information, to receive the information, and then be able to make that determination, what should be redacted, what should be proffered as evidence at trial, and so on?
So like it would be a statewide agency or something that would receive that and make that determination?
Hypothetically, yes.
Okay. I think that the same things apply anytime you have, with the way it is now. I think that, as long as there are mechanisms in place to protect the security and integrity of the data, I think that as long as, there are understandings about who the data belongs to, that the data belongs to the agency, which is something that we see when a third-party vendor manages the data, for instance. I think that those are the key things, and I think, I don't know how agencies would feel if a third party was making that decision about whether the footage on this date was evidentiary or not, or what it had. I think I could see some resistance to that, in the sense that they would feel that they know better in terms of what their officers were doing and what the footage really contains. But I could see that there could be some circumstances in which there would be some objective criteria that could be used to do that. Okay. So, it may not be the easiest fight to win, but I could see there being a merit to that.
Well, thank you. Thank you for your testimony, your work. Thank you, Mr. Chairman.
Representative Anthony, then we have Senator Hastings.
Thank you, Chairman Raoul and Chairman Neckwitz. Ms. Miller, thank you for your testimony. I found it very interesting and really enlightening. One of the things that I wanted to ask you in your studies, I'm a former sheriff's deputy and city cop, and I was also a policy writer for the sheriff's office. Could we use the dash cam policy to enact policy throughout, allowing other departments to follow that policy as far as coming up with one?
Yes, I think that's a good question, but we had a lot of places say that they started to do that. I think that there are aspects of the dash cam policy that can be adapted, especially when it comes to retention and storage and things like that. I think the biggest difference is the fact that the dash cams are stationary and the the body cameras go inside people's homes. They get up close, like I was saying earlier. So I think in that sense, there does have to be an additional an additional part to a body camera body camera policy that doesn't exist probably with the dash cams. But I think they can provide a start, and I think they can provide guidance in terms of how the agency discloses electronic records and retains electronic records and stores electronic records. I think it's just in terms of the recording policies itself, there would have to be some differences.
Okay, I also, as I listened to your testimony, I didn't hear anything about the encounter with juveniles. How do we, cross that fine line?
Yeah, I think it's my understanding that most public disclosure laws would preclude disclosing images of juveniles. There would be redacted and things like that. So I think that in terms of that is where those protections would come into play. And it's a hard issue. I mean, a person is called to an event at a house and they go in and there's children there, and do they turn their camera off because of that? And I think that's where those back-end protections have to come into play. The public disclosure laws, the redaction, the shorter retention times if possible, those sorts of things.
I just did a police ride-along with the city of Chicago in the 10th District, and I was amazed. And 90% of the calls we responded to were juveniles. In your opinion, well, let me say it this way. How important is it to have a eavesdropping law in the state of Illinois? Because right now it's basically non-existent. And I mean, when you look at undercover officers, are we looking to have undercover officers wearing cameras? I mean, those are questions that need to be answered.
Yeah, that part is a little outside of my knowledge in terms of the eavesdropping laws. Most of the states that we dealt with did not have two-party consent laws of any sort. Only a handful, I know, still have them, and I know that that's a big issue that's occurring here, and I know that Pennsylvania, for instance, just gave the exception for body cameras, that it would allow body cameras. So I think that is, it's definitely a big issue in terms of body cameras, the two-party consent versus one-party. But in terms of what a good law would be or not, I don't want to wade into that.
Thank you.
Senator Hasty?
Ms. Miller, thanks for your testimony today, and you have a very impressive background, and your 43-page report was very intriguing.
Thanks.
So in towns of Topeka and Daytona Beach, in which you referenced, data storage, I guess, is one of my questions in terms of cost. For a town of Daytona Beach is a very tourist attractive town, and so is Chicago. Is there any cost estimates in terms of what they spend on data storage?
Yeah, I think, if I remember right, with Daytona Beach, I think they spend a couple $100,000 a year, maybe, on data storage. It's usually, and again, I think that some of the vendors who are here in the technical panel could speak a little bit better to this. I think a lot of times it's part of a package. They purchase a certain number of videos, and at the outset, maybe the data storage is a certain amount for 1 year, and then it changes different years. But I believe that, like, Daytona Beach said that it was maybe $150,000 a year, $200,000 a year, depending on the year. So.
And do you know if there's a subsidy from the state that sort of incentivizes them to have that?
I do. I think some states do have, will give grants and subsidies. I think that there's a lot of private donors now that are starting to do it. But yeah, I do think that some places have state grants to do the. And I couldn't tell you exactly which places, but I do think I remember hearing that during our research.
Thank you very much.
You're welcome.
Representative Sullivan.
Hi. We've kind of tackled a lot of the policy procedural aspect of how you'd implement this. Policy-wise, one of the intriguing facts that you brought up on why we would do this, why we would not, was your Rialto, California example of use of force incidents that were down 60-some%, I think.
60%, yeah.
Okay. Do you draw any conclusions to that? Is this the people know they're being recorded, and so they're less likely to engage the officer, therefore escalating the problem? Or is it cops less likely to use force because they know what's chicken and the egg scenario?
Exactly. Well, we asked Chief Farrar, who's the chief in Rialto, that very question, and he said, I think it's a little bit of both. I think it's actually three things. I think it's the citizens, saying, look, I'm on camera, I'm not going to fight with this guy, with the officer. I think it's the officer professionalism. being improved, and its unfounded complaints not occurring too. In terms of the, use of force incidents is different, but in terms of the reduction of complaints, it's also the fact that
Sure.
we had many people say, we will have people come into the headquarters, say, I want to file a complaint. They'll say, okay, let's go get the body camera footage, and the person will turn around and walk out. So
And
I
that's
think
the
it's-
second aspect of the policy is we're reducing costs that way. And
That's
so-
exactly right. That's why, all these agencies that said, oh, it's so expensive, but we love having them anyway, and it's worth it because, no telling how much we're saving on cost. I think the London Metropolitan Police Service they're getting ready to implement body cameras, and they're huge, obviously, and they're doing a big cost-benefit analysis. So it'll be interesting to see what they find, but we are definitely hearing that it's worth it for agencies for those reasons.
Okay, but so in this limited experience in Rialto, California, the chief himself said it's probably both, both aspects. Okay.
Yep.
Thank you.
Let's add Representative Rebelletti to the row. I have one final question, and it has to do with responding to the home call, right? So one of the things that make me a little bit apprehensive is it's a question of expectation of privacy, and obviously out in the public. There's a diminished expectation of privacy. I don't think it's totally eliminated, but I think there's certainly a diminished expectation of privacy. You use as your example a domestic violence situation, but that's not the only circumstance where an officer may report to a home. And let's say it's loud music or alleged loud music or something like that. How do you balance the use of body-worn camera in one of those?
Yeah.
I can understand a domestic violence situation,
Sure.
but
It's a very tough thing to balance. I think the police officials we consulted with said a couple of things about that. They said, well, one, most of them take the approach that if their officers have a legal right to be in that home, then they have the legal right to record. So if they're called there on a call for service, if they have a warrant to search or anything like that, they then believe that they have the right to record. As part of that, they say, we're also, when we get to these calls, we're taking photographs, we're writing reports, we are already doing all of these things that you could say infringe on privacy, that could be also made public. So I think that there's the idea that the body cameras, while it is more than that, it is still along those lines of being, an investigative tool, much like writing a report or taking photographs. And so I think, again, that's why the public disclosure laws on the back end are such a key, because a lot of those things that you described are going to be exempt from disclosure because they pertain to an investigation or something like that. So, but it's a hard thing to balance, and I think that balance of privacy versus transparency and the need to accurately document evidence is one of the biggest things that agencies are grappling with.
I guess the hypothetical I'm dealing with is, let's say there's an allegation of disturbance in the home and it's invalid, right? It's like loud music or
Right.
something like that. You could say there's an investigation, and in the circumstance, the person doesn't want to be recorded, right?
Right.
And they're in their home.
Right.
So then you've got a really conflict there
That is,
between a legitimate
Yeah.
expectation
Yeah.
of privacy
Yeah.
and
It is-
not an urgency situation, right?
Right. Yeah, I mean, I think those are the kinds of things that agencies, they're going to have to think about. They're going to have to think, before they even get body cameras, is this something that we want to do? And, but, like I said, that the approach that most people that we spoke with take is that if they have the legal right to be in that person's home, then that's part of the process of the call for service or being there, so.
All right. Thank you.
Thanks.
Next, we have our Fraternal Order of Police panel. We have Sean Smoot from the Police Benevolent Protective Association, Keith Turney from the Illinois Fraternal Order of Police, and Dean Angelo and Jay Ryan for Chicago Fraternal Order of Police. Good morning.
I don't think your microphone's on.
There we go. First of all, thank you very much, Chairman Nekritz and Chairman Raoul, for giving us the opportunity to address the committee this morning. Despite great trepidation by some of our members, many of us in the law enforcement leadership community have been advocating to have the ability to use this technology for a number of years. Rank and file input and buy-in is essential to the successful implementation of this new technology in policing. And many issues that were addressed by the previous speaker and that will be addressed by myself and others will also have some collective bargaining impacts as well. So we believe that it's extremely important that we be involved in the discussion. We certainly don't want the only purported record of an event to be something that could be a potentially modified or edited piece of video taken by a cell phone or iPad. We favor being given the ability to have an official record, so to speak, rather than to rely on video evidence that is not of evidentiary value or quality. We know that without proper safeguards, it is easy to edit and manipulate video. I have a 16-year-old daughter, frankly, that's quite good at it. And I could be happy to share some videos that she's made with the committee in a private setting, if you'd like. But the use of these cameras has some drawbacks as well and raises some significant concerns for us and for individual officers. I guess I just want to say at the outset of my testimony that we look forward to working with the Judiciary Committee and with the General Assembly to address these concerns in a professional and productive dialogue. We know intuitively that cameras have positive effects, and science now backs this up. There have been several studies, including one that was done by the London Metropolitan Police about 4 years ago, in which it was shown that complaints against officers during the period of time, and not all officers were wearing cameras, but the public knew that there was a study going on that several officers were wearing cameras, and during that period of time, complaints against officers was reduced by over 90%. That's a very tough number to ignore. We believe that officers are protected from bogus complaints, and the public is protected from police misconduct. The science shows that complaints are reduced anywhere from 70% to 90%, 88% in Rialto, which was a study that you just heard about. It was probably the most recent study. We know that now that this technology has been used, at least on a trial basis in several departments, that situations tend to de-escalate rather than escalate when cameras are present. I don't know why exactly, but we know that it's the case that that occurs. We have seen from the studies 50 to 80% reduction in the use of force. Rialto PD saw a 55% reduction in the first 6 months that they implemented a camera program. The bottom line is, and many of you have heard me say this before, everyone behaves better when they know there's a camera around. I don't want to focus entirely on police conduct, however. These cameras have are an extremely valuable tool when it comes to collecting criminal evidence for criminal cases. Video evidence, as an example, has become the predominant evidence in DUI and reckless driving cases in the state of Illinois. The potential for capturing evidence that would otherwise be lost or destroyed because a police officer is wearing a body camera is extremely high, particularly in cases or scenarios where an officer comes on a scene and there's a victim who requires medical attention. The fact that an officer has that camera on and captures the scene as they arrive then gives video or photographic evidence of where everything was before the paramedics arrived and tended to the medical needs of the victim or a person who called for service. Now, that's not to say that that doesn't create some unrealistic expectations as well. To Senator Nolan's point, I think he called it the missing video phenomenon. The people that I talk to in the criminal justice system call it the NCIS phenomenon. And what the NCIS phenomenon is, for those of you who don't watch television, there's several shows now called NCIS, and they all deal with forensic evidence and investigations, and they all tend to wrap up within an hour from the time the crime is committed to the time the person either confesses or is prosecuted. And so now we see juries in criminal cases many times asking, well, where's the DNA evidence? How come they didn't have DNA? Why did they arrest this person without DNA? Well, we all know that it takes weeks, sometimes months, to get DNA testing done. It doesn't happen in 10 minutes like it happens on NCIS. And so whenever these new technologies come into play, I think that creates a danger of people having the expectation, well, if there's not video, it must not have happened. And I think that needs to be borne in mind. I think also it's very important to bear in mind that the use of these cameras is not a Pandora's box, as many of the people that I represent fear it is, but it's also not a panacea for policing. Body cameras are a tool, and they have pros and cons just like any other tool that first responders use. The key is to have solid policy on how the tool can and will be used. Based on my knowledge and experience working with the United States Department of Justice and police departments around the country, I've identified for my testimony today, and I'll be very brief in running through it, but some concerns and issues and questions that will arise. We have advocated, and this came up in the prior witness's testimony, we have advocated that these cameras, if they are permitted to be used, that officers in full uniform conducting their official duties be permitted to wear them. There are different policies around the country. Some departments require SWAT officers to wear them. Some departments allow plainclothes officers to wear them. We feel that if you have it as a solid policy and the public knows that a police officer in uniform could have a camera on, then the public is informed that their interactions with that officer could be recorded. Just like people know when they get pulled over, there could be a camera in the dashboard of the officer's car now, because we publicized that when the General Assembly passed the law allowing dash cameras. Training is going to be essential, not just initially when officers are assigned, but also we think continuing training will be necessary and will be an additional expense that ought to be considered. We certainly agree with PERF's recommendation with regard to that training. One issue that has not come up that I think is important to also note is a lot of what the camera captures has to do with where the camera is worn. And so there are actually very few body camera policies around the country that address this issue. Those that do generally require that cameras be worn above the midline of the torso. So that could be anywhere, above the, I guess, I would say the trouser line or the belt line. It's important to keep this in mind because a camera worn in the center of an officer's body mass or in the center of their chest will not pick up exactly what the officer sees at the time. So these things may not be a point of view. You may not capture a point of view of the officer. And as all of us know, they also don't account for the depth perception and other things that the human eye does. So they're not, they're not the panacea that's going to show everybody exactly what the officer saw. They won't capture the same field of vision that an officer has. They don't. And in high-stress situations, it wouldn't be uncommon for officers to see things differently than a camera actually sees them. We know from officers who are involved in critical incidents, and frankly anyone who has a gun pointed at them, their brain immediately focuses on the barrel of the gun, and what's happening on the sides and the periphery, the brain doesn't process. where a camera might. So they won't necessarily mirror what the human eye or what the human feeling is. I think probably the biggest issue, and PERF has dealt with this to some degree, but I don't think conclusively, is when body cameras would be activated. And I think this has a lot to do, frankly, with what the General Assembly does in terms of protecting this data under the Freedom of Information Act and other public information disclosure laws. It's not really practical for officers to have cameras on all the time. They will have to be manually activated and deactivated. Just from the data storage standpoint alone, it would be unrealistic to do that. And as somebody pointed out earlier, there's a concern, and actually probably several concerns when you're talking about, I believe it was you, Representative Anthony, talking about what do you do in the case where an officer encounters a juvenile? And what happens to that data that's collected after an encounter with a juvenile? HIPAA issues. What happens when an officer records HIPAA information, and what happens to that information if it's somehow later on disclosed? Police officers respond to hospitals all the time. They escort to hospitals all the time. That's a significant issue. And I think we will have to talk about and address the issue of private residences and other private locations, whether notice has to be given. And the fact that the technical limitations, which I'm sure you'll hear more about later, about battery life and storage capacity. From a standpoint of the officer on the street, policies are going to have to exempt certain things from being recorded. Meal breaks, locker rooms, restroom breaks, times when an officer is present when a suspect or a victim is having a medical examination, during autopsies, which officers often attend, if a citizen requests that they turn off the video. When dealing with victims, particularly victims of certain, what I will characterize as sensitive crimes, I think you can probably come up with your own conclusion as to what would constitute a sensitive crime, but I don't think any of us want to see a YouTube video released of a police officer interviewing a rape victim, for instance. Certainly when no citizen is present, undercover activities, dealings with confidential informants, and discussions with people who the officer may have a legal privilege, like their attorney or union rep or the city attorney. So these are all things that are fairly universally exempted under the policies that are in place around the country now. I would think that these are things that we should be keeping in mind when looking at implementation going forward. Somebody asked earlier, it may have been you, Senator Raul, about when is it unsafe or impractical? How do you make that judgment call? And I think that there has to be some recognition that every interaction that a police officer has with a member of the public, whether they're a suspect or not, whether they're responding to a crime or not, these are fluid situations. And they can, we had 2 officers who were shot about 48 hours ago in McHenry County who were responding to a domestic violence call. One of the officers went to the door and knocked on the door, was literally shot through the door by the suspect. Certainly wasn't expecting that response when they knocked on the door and would not have necessarily known to activate a camera at that time. Officer safety is going to be an issue when they're dealing with those situations. And frankly, police officers are not robots. They're human beings, and they get involved in situations sometimes with absolutely no intent, may not realize that they haven't activated the camera until the incident's over with because they were fighting for their life at the time. So these are things that I think, have to be recognized, what the impracticality is. Certainly if an officer's safety is in danger, I don't want them worried about whether or not, and I don't think you want them worried about whether or not their camera's on at the time. We want to make sure that everybody goes home safe, and that should be our ultimate focus. And I think the big issue really for a lot of us will be, how is this data going to be protected? Because if it's not of evidentiary value, if it's not information that can be used as part of a criminal case or a civil case that somehow has been flagged as such and preserved as such, it ought to be destroyed and not subject to public disclosure. You know, we have some, there was discussion, and I think one of you had asked, I apologize, I don't remember exactly who it was, had asked about how long should this stuff be kept. We have a pretty good system in terms of retention of video with the dash camera system. And under that system, if it's not evidentiary, after 90 days, it's destroyed. And that seems to have worked for several years pretty well. I'm not aware of cases where it didn't. So I think the need for FOIA protection is something that is something that the General Assembly needs to do. A lot of these other, you know, I don't expect that the Judiciary Committee or anyone in the General Assembly wants to get into the minutia of every policy detail here. But a lot of what policies can and will be implemented will hinge on what the General Assembly does in terms of protecting the data. And so I realize that I've covered a lot of ground and listed a lot of unanswered questions. But the men and women of law enforcement that I'm here to represent stand ready to participate with you in determining the right answers. And the right answers for the criminal justice system, the right answers for police departments and for police officers, and for the public which they are sworn and which they attempt to serve and protect every day. Thank you very much.
Thank you. We'll let all the witnesses on this panel testify before we take questions, with one exception. There's an exception to your rule that everyone behaves well behind camera, in front of a camera, which is a politician exception to that.
If I may introduce to my right is Dean Angelo Sr., the president of Chicago FOP Lodge 7, the largest singular collective bargaining unit of police officers in the state of Illinois, and one of the largest in the United States.
Hello, everyone, and thank you for allowing us this opportunity to participate in this conference or in this hearing on something that our members sit in two camps as far as their concern about cameras. One is no, and the other one is it's coming anyway. So they're not ready to buy in by any means. They're very suspicious by nature. This is a job that caters to suspicion by the way we are involved with certain elements of the public on a regular basis. I took the police test in 1975, and I've watched this department change drastically. I've watched policing change drastically. Just prior to my arrival, radios were clipped to your hip instead of in the car. Officers didn't like that because they had to carry something around with them now. Shortly after that, there was a change to use vests, bulletproof vests. Police officers didn't like those. They were too heavy, they were too cumbersome. In the summer, they made you sweat, and it was something that was very reluctant for people to utilize. We would take our vests and we'd put it in the trunk. Not a smart move, but that's what we did. Pepper mace came out. No one wanted it. It's a tool that allows you to do something less than hands-on tactics to secure someone. It's useful now. Tasers was another element that was not forced, but offered as another tool. Again, where are you going to put it on my belt? My belt's too full. My waist is too small, although most of us don't have that problem. But again, it was fought and it was resisted, and it's an amazing tool. to use something other than deadly force. Car cameras was the next one. You've got to be kidding me. They're going to film everything we say to people, everything we do, every encounter, and we see regularly where officers are saved or crimes when they're murdered at a traffic stop are documented. So again, it's a useful tool. This may turn out to be a useful tool, but you need to convince my members. I have over 10,000 people. They are reluctant by nature. They need buy-in. This is part of that. This could be the initial step to that buy-in. It's critical that we are at that table. If you want them to participate, if you don't want that event to occur with the breakdown of that camera 2 times in a very short time, then let them sit at the table. I respect chiefs of police associations, and I know that bosses are in the business of setting policy and setting standard, but let the men and the women who have boots on the street participate. They're the ones that can tell you if they're effective. They're the ones that are going to tell you if the device works properly or if it doesn't fall off as they run down the street or down the alley after someone. And now they stop and retrieve a $600 camera so they don't get written up for losing department property. The guidelines that you set and the policies that the departments put together are what the officers are held to. That's where their discipline comes from. If you set a policy where they are required to activate on this incident or that incident, or not here and not there, and they forget, or they fail to turn it off, and it's documented, and you write them up, you're going to lose your population. You will have breakdowns. You will have that gap in videos. You will see that there's not the information coming forward that you're looking for. This is an opportunity to protect my members because my members are confronted by certain populations in this city regularly that have no respect for them. They call them, they ask for assistance, and they get in their face. This is a difficult thing for officers to deal with on a regular basis. If you look at some of the film footage of what the gentlemen and the women standing on the front line in Ferguson, Missouri are going through right now, you would think by the reaction of the police officers that are being subjected to screaming and middle fingers stuffed in their face and threats placed on them from the left and the right and 2 inches from their face, you think they were a mannequin, but they just stand there. The difference with this is put a camera on those individuals so we can see who's the ones that are screaming at them and getting in their face. This is not an easy job. I imagine that the people that are proponents of the gotcha type of mentality with this environment of using body cameras are going to be extremely surprised what an officer confronts on each and every day of their watch. There is a segment out there that you have no idea exists. There is a population that my members deal with regularly, every single day in this city, that are going to open individuals' eyes. So in those areas, in those situations, when my members are confronted in a manner that is unknown to most of our population, eyes will be opened, and you will see what heroes you have on the streets every day. How tolerant they are, how professional they are, and how good they are at their jobs. This is an opportunity for them to get that recognition they so deserve. I hear some of the policies or some of the suggestions on when to turn the camera off and when to turn it on. Those are very subtle today, guidelines, but they become policy at some point in time. If a victim of a crime, a sensitive crime, as Sean put it, winds up giving up their offender in the course of that interview and the camera's off, you lose that. So do you really want to shut it off at that time? Because people are so emotional during those events. Sometimes they say things they don't realize they're saying, and sometimes they'll remember something they don't really know is going to come back to their memory. So evidentiary-wise, we need to think about how that's going to work. My job is to protect my members, to make sure that what you do from this point forward keeps them in mind. We have so much going on in our lives and so many fingers being pointed at the public sector right now. We're willing to participate, but please don't, cut us out. There's too much at stake. Our members deserve it, and we're willing to participate and see this thing go forward, but we would like to be at the table. And I brought my subject matter expert, one of my trustees, Jay Ryan, who actually is a trainer on these devices. So I'll offer Jay an opportunity.
Good morning. I do train on the side for Taser International and teach body cameras and flex cameras along with other devices, and I would be willing to assist in any matter to provide you any information regarding the equipment itself. But I've also been providing Dean with quite a bit of information regarding how the equipment works, limitations, and effectiveness.
Madam Chairman, Mr. Chairman, thank you for this opportunity. My name is Keith Turney. I'm second vice president with the Illinois Fraternal Order of Police. I'm also an employee of the FOP Labor Council as well. Retired police officer after 31 years with the city of Joliet. I retired with the rank of commander, and I've been currently working for the Labor Council for the last 5 years. I'm here on behalf of the FOP State Lodge, however. Ms. Miller made a great presentation this morning for you. I implore you to review the document that she prepared from PERF, because it in fact does hit almost every issue that we are all struggling with today in regards to body cameras. Mr. Smoot makes some very good analogies, as well as Mr. Angelo, so I am not going to belabor those. I will tell you that you'll find in the PERF study, and if you've heard from your two previous speakers, that to get buy-in on any type of a program such as this, you're going to need the cooperation of the rank and file worker. As you'll see in the PERF study, that is also recommended. Because it's a nationwide study, they don't specifically talk about unions, because there are many states that PERF has a presence in that doesn't have unions. However, we are different here in Illinois. So we implore you and we thank you for this opportunity to participate in this. I will tell you that the only places that we have seen pushback in organizations with body cameras are in those organizations that did not work with their employees to implement the programs. There's been a couple places in Florida where this has occurred, not Daytona. They have been very progressive in what they have done. But there have been other areas where the rank and file have been arguing and fighting in public over these issues because they were not consulted with. So I think it is very important from our perspective here that we do have a seat at the table, and for that we thank you very much. And that will conclude my comments. Thank you.
All right, thank you. So there's been a lot of mention with this panel about the table, and I guess there are two types of tables, right? You know, there's a table that you're at right now, communicating to the legislature, and there's the table, the bargaining table that you are with your respective departments, and obviously we're dealing. When we talk about such policy, there's policy made on a statewide level, and there's policy made on the local level, as was discussed with the first witness. So I guess in a nutshell, what I would ask of any of you all in terms of concrete policy that you would want to, because you're at the table right now, right, that you want to see from the state, because that's what we're dealing with, right? And maybe in an essence of when we implement whatever we implement at statewide level, it has some impact at the agency level, but we're not going to be at every department determining what the department level policy is going to be. So what is it would you that you would specifically want to see in a statute that would speak to body-worn cameras?
I think, speaking from my perspective, and I certainly would welcome others to chime in, but we have a very significant and successful history in the state of Illinois in terms of creating model policies that then can be modified by individual departments. And frankly, that has almost always been done with the facilitation in enabling legislation, with the facilitation of the Illinois Local Law Enforcement Training and Standards Board. And so, you know, what I would suggest is that we enter into a similar type of process here. If at some point the General Assembly determines that our statutes will be changed in some way in terms of the eavesdropping law to provide police with this tool, that that statute also would include the clause that allows the Illinois Local Law Enforcement Training and Standards Board to convene a committee which includes appointments from the organizations represented here, as well as the chiefs of police, the sheriffs, and some other interested parties. We have a history of doing this. We did this in establishing the policy on how to deal with persons with mental illness. I think most recently it was done with a model policy on alcohol and drug testing for police officers. We've done it on use of force, pursuits. So there's a long list of statutory mandate requiring the Law Enforcement Training and Standards Board, and I know they're here. I think maybe they'll testify later today. But that has been a system that has worked, and then we've been able to come up with basically a model policy which some departments can just adopt, and others may want to modify in some ways to meet their own. But so that would be a third table, I guess, that I'm describing there. And I don't know if anybody else has other ideas, but that would be mine.
Mr. Chairman, I think it's clear to all of us that there's a two-prong approach to the body cameras, and the one approach is, of course, legislatively, and we've talked about FOIA and eavesdropping. I think those are going to be your biggest burden to overcome. I don't know if the ACLU is on the agenda today or not.
They are.
And I am aware that I believe their perspective on body cameras is they should always be on, never be turned off. Maybe not, maybe it's changed. But what I would suggest is that, yes, that is your burden, and we want to help in crafting that legislation. But then I believe Mr. Smoot is correct for the policy and how we're going to implement statewide. You know, I think that should be at a lower level, and that should be handled by your local municipalities, your local governments, because what occurs up here in the north is totally different than what occurs down in the southern part of the state, as we all know. There's different demands, there's different funding issues, there's different demographics. So I would suggest, yes, it's a two-prong approach. Thank you.
Okay. So with regards to the first prong, and you mentioned specifically FOIA and eavesdropping, is there anything you want to share specifically in terms of recommended state policy on FOIA? Eavesdropping is broad because it's all eavesdropping, right? You know, it's I mean that.
Of course. Well, you know, in the areas of FOIA, you know, police departments are severely overburdened now with FOIA requests. Now that we have videotaping of incidents within a community, even potentially in someone's private home, you know, I think Ms. Miller brought up these issues on the release of this information and how it's, you know, is it going to be accessible to the public and to who? You know, I've heard some discussions where people were going to be allowed, if they were videoed at all, they would be allowed to request a copy of the video. So now can you imagine a police officer's in front of a tavern where there's, you know, 20 or 30 people milling about, and he's involved in an altercation with a couple of them, and all of a sudden 30 or 40 people show up at a police department and all want a copy, you know, of the video. So, you know, we have to be careful in those issues. And then, of course, there's the differences between routine operations and evidentiary evidence. So, you know, that's another issue that has to be looked at.
The last question. We've heard from both the first witness and from you about this study at Rialto. That was a department study?
Rialto, California,
Yeah.
yes.
Have there been any independent studies at any departments?
That study actually was conducted independently by a university.
Okay.
So that was an independent study. And I believe that there have been 2 or 3 others that I've read about, and I'll be happy to find those and provide those to the chairman.
I appreciate it. Representative Williams and then Senator Nolan.
Thank you, Mr. Chair. I want to just reiterate what the panel said, that any, you know, as far as we move forward with procedure, that it's just absolutely critical to have the rank and file involved, and rather than imposing a policy on them. So thank you for making that point. But my question might be to the chairs. Can you clarify what role the state plays as enabling legislation required, or could a department today move forward with some utilization of the cameras in Illinois?
Right now, there is no eavesdropping law in the state of Illinois. And so, I mean, the question you raised brings one point that I forgot to make. As we talk about getting a committee together to hash out a model policy, what we have waiting sort of impatiently, the sky hasn't fallen, but I mean, we're operating without an eavesdropping law in the state of Illinois, and I'm uncomfortable with that. I don't know if I don't think I'm the only one here that's uncomfortable with that, but I think it's in the interest of the state that we pass something as soon as possible.
So would the legislation actually address the cameras per se, or would the policies just evolve out of that, the guidelines in the statute, the eavesdropping statute that we do?
I'm of the individual opinion that the reason we haven't passed anything is because we haven't specifically addressed body-worn cameras. And I think in order for us to pass something, just practically, politically, however you want to characterize it, we have to address it in some way.
Okay, thanks.
Mr. Chairman, can I just respond very briefly? I think the point is well taken. There is no eavesdropping statute, so these things could be used now. One of the big concerns that I have, and we have, I think, and you should have, is there's also been no amendment to the Freedom of Information Act. And we have a public access counselor that has essentially ruled, I think in almost every instance, that any record that a city has pertaining to the police department, it can be disclosed or should be disclosed under FOIA. So from our perspective, it's almost like the perfect storm. Anything goes in terms of eavesdropping, and everything's open to public disclosure on the other end, which I think is a terrible result for citizens as well as police departments.
Representative, the only thing I would add is that you know, there's even if our eavesdropping law were in place, there's nothing to prevent the video portion of this from going ahead if departments wanted to do that. So there may be, I believe there are departments that are in Illinois that have been looking at it, regardless of what happens with the audio portion.
We have Senator Nolan and then Representative Rebeletti.
Thank you, Mr. Chairman. Mr. Attorney and Mr. Smoot, you both bring an important consideration of mine, this idea that the police departments will be so belabored that they'll not be able to fully respond to FOIA requests. So what do you say to the notion that I had mentioned earlier regarding a disinterested third party sanctioned by the state to receive this information, and then they be the ones to respond to these 20 or 30 or so individuals outside the tavern that you identify, rather than requiring the individual police departments to do so?
Could I respond? I know you didn't direct it to me, but we have a situation in Chicago right now when FOIA requests on disciplinary histories are taken anywhere from 2 to 4 months for an individual request because of the lack of internal administrative staff at headquarters. And the amount of calls for service every day in Chicago are 1,000. And every week you're looking at 10,000. And every month, and you can only imagine the amount of manpower that would be required to not only review, but then to categorize and house and then retrieve that. It's going to be a pretty huge task.
So you'd be interested in having somebody else do this work?
I'm sure the mayor would. Yeah.
How about you? You're the
Cost-wise.
rank and file. That's the mayor, but you're asking for
Rank
buy-in.
and file
I'm asking you.
would only be concerned about the protection and security of those videos. You know, as long as it is in a secured environment and it cannot be, you know, I mean, what's secured now? Everyone's getting hacked. But if it's not out in the cloud somewhere where someone can tap into it, you know, that's what people are concerned about.
So I take from that you perhaps might like some oversight of this panel or this entity, whatever it may be.
As long as my members are protected, that's my concern.
And I would just add, first of all, as long as the safeguard is there for the data, and so that it's not a situation where somebody can just come in off the street and say, hey, I want all the video from everybody that you've ever taken in the last 90 days. You know, clearly there are going to be a lot of situations that are captured on video that are things that should remain private. Whether the officer has the camera on intentionally or unintentionally, maybe they realize they're in a situation where the camera should have been turned off after the fact and got somebody in a situation or saying something that, you know, we wouldn't want disclosed. For that own person's safety, by the way, in a lot of cases. So you know, from that standpoint, I think that's the broader issue. In terms of a third party responding, you know, as long as their facility and their employees are Illinois residents, I think, you know, that would be an overriding concern.
One other concern with third party is then you're going to have to look also at the standardization of how much data is kept, because you know, some departments may want to submit 7 years of data and others with 7 weeks. So now you're talking standardization, and that may be burdensome because one of the PERF recommendations is, you know, you have to have some individual input from the communities as to even how much data you can afford to save. So when you start that standardization, that's another hurdle you're going to have to address.
Representative Rebelletti.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here. When Representative Neckrits talked about the video portion, when you walk in Chicago, you're already on video. There's cameras everywhere. In Joliet, there's cameras. Depending where you're at, you're already on camera. There's video footage. But interestingly enough, video isn't always very helpful either, as we've seen. And having done a jury trial on delivery of a lookalike substance, the first thing the jury wanted to know is why wasn't there any audio? What was I hiding from them? Because officers were talking and the defendant was talking, but there was no words exchanged. I couldn't explain to them that there's an eavesdropping statute, and the reason the camera, there wasn't audio is because eavesdropping didn't allow it. So I guess my charge to you is, when do you think that the cameras should be on? At what point in time should the officer put the camera on from a procedural standpoint? I can only imagine that entry on a search warrant, if feasible, having dealt with those cases where defendants or multiple subjects make all kinds of allegations about how police entered and did certain things, versus I have officers telling me that dogs were released on them, that guns were pointed at them, that there were a number of subjects that were in the house that fled after the police got there. Do they have it run constantly when they're on bike patrol? And so no matter where they're riding, the camera's always on? Is it on once they leave the squad car? and that's what I think one of the discussions should be, because obviously at some point the courts are going to get this. And there's going to be some procedural challenges to this as to when it should have been activated and when it shouldn't be.
It's kind of the NCIS phenomenon that I spoke about in my testimony. Absolutely, it happens all the time. I mean, and the fact of the matter is we have state's attorneys around the state now that if a police officer arrests someone for DUI, if there's not video of that DUI, they'll dismiss the case. They just won't take it forward. So I think that's a very valid issue that you're raising, and I think, you know, in terms of the policies where it's successful policies I'm aware of, the officer activates the camera when they're going to have contact with a citizen, and they deactivate it at, you know, the appropriate time when that contact is over with, unless it puts their safety in danger or is for some other reason impractical to do.
And I agree with you, because in that same case, the video went out, and then the jury thought that what was the officer hiding and why wasn't there the audio? Then they wanted to know why the plastic baggie that was found wasn't tested for DNA, because again, back into the NCIS or CSI phenomenon, we assume that within 48 minutes we can solve the crime from arrest all the way to jury and probably to an appeal. So that's one of the issues. What are the general fears from the officers that you're hearing? Because I was just at the DuPage Chiefs meeting a few weeks back, and there were some folks that were gung-ho, when are we going to do this? And there were others that said, you know, over my dead body, we're going to do this. I have no desire whatsoever. Is it based on the age and experience of the officers? Is it fear of technology? Maybe you gentlemen can help me based on the different departments you're familiar with.
I think it's part of that, but I think one of the big fears that I hear is that there's going to be a supervisor somewhere in the police department who's sitting in a room basically trolling the video, trying to find, you know, something the officer did that's outside of policy. And so that's a big fear, like Big Brother's constantly looking over. Did you put your seatbelt on when you got in the car for the third time that day? You know, those are the kinds of fears I think that I hear a lot of. I think you raised an important issue at the start of your question, though, too, because, you know, what officers have come to realize, particularly lately, is anybody with a cell phone can record them video and audio. Now, I mean, I have one of those phones on my hip right now. If you can show me how to turn the audio off, I'd love to know, but I don't think it's possible to do. So if I choose to record what you're doing with my phone, I'm recording you with video and audio. And I think part of the sell to our members, frankly, is the fact that they're going to have their own record of what really happened, and it's not a record that can be tampered with because of the way this equipment works. And I think you've got technical people here that can explain to you how it works. But I'm very familiar with the products, and I'm very convinced that, you know, no police officer that I've met would have the ability to tamper with the video before it gets uploaded into the department's system. So,
is there a time frame that you believe that the data should be stored for? Is 90 days enough? Is it 3 years? I mean, is there a certain time frame that you would feel comfortable with, or your members would feel comfortable with?
I think we've already lived with the dash cameras and the rules that pertain to keeping that video, and under that law, it's 90 days, unless it's evidentiary value, in which case it can be used, you know, when the case is disposed of, the video can be destroyed. But once it's in the court record, as a practical matter, it'll be in the court record. So, but if others have other contrary views to mine, I'm certainly open to listening to them.
No, I believe the question was asked earlier, if the legislation we have in place now for dash cams could be used. And I think our response would be that would be a good place to start. It would be a good basis to start. To address your question, though, when to turn them on, when to turn them off, I think it's very important that there is a certain amount of officer discretion there. For example, you know, an officer who just walks up to a citizen to have a casual conversation, you know, do we want really to record that? Does the citizen really want that recorded? But, you know, but let's say, you know, halfway through that conversation, the citizen starts acting in a bizarre manner or strange manner. Then the officer should have the ability to flick on his camera to then start recording this interaction, because now it's turned into something a little different. And I think PERF mentions in their report that you know, it should be activated whenever an officer is involved in a law enforcement activity. And now we get back into that policy, because actually you would have to write policy locally as to, you know, what the agency would determine as an activity that is law enforcement related.
And your thoughts on giving notice to an individual that they're being recorded? One of my concerns is that now we're asking you to play attorney out in the field as to when now this is we've come over from a regular casual encounter on the street to now it's a law enforcement action. I think that should play out more in the courtroom. What are your thoughts on that? Because one of my thoughts is what you're talking about with once the officer leaves a squad car, maybe if the lights are activated, maybe that camera should automatically go on as soon as that officer leaves the squad car. I don't know what your thoughts are on that.
Well, I believe Mr. Smoot made a good comment in regards to the public, you know, after a while will just become accustomed to that whenever their interaction with a police officer, they're going to anticipate that they could possibly be videotaped, just as they are now with the dash cams. So this might be a transitionary thing, and I can see an implementation in a local police department where, you know, the officers maybe initially would be instructed, make sure you inform people that you are videotaping them, you know. And then as time goes on, that may wane off because the society will become more accustomed to the practice and it won't be necessary anymore. But I know PERF does recommend that in their study.
And do you think it needs to be legislated where we tell you where the camera should be? I mean, obviously, we don't want it on somebody's knee or ankle, but should we legislate that?
I think that would be a very dangerous thing to do, because the technology is evolving. And, you know, there are some products that can actually be clipped to your sunglasses or your eyeglasses. There are some that actually clip to the shirt. There are some that clip to the lapel. And the problem when you legislate location and things to that degree is when new technology becomes available. In order to use it, you have to re-legislate doing it. So I would be hesitant to recommend doing that.
Thank you very much. If you want to continue on. But.
Just that I would also discourage a specific location for the camera location on the officer. Body cameras in the upper part of the body will pick up a field of view of approximately 130 degrees. It's recommended by the manufacturer to have it in the upper part of the body, so it will pick up that field of view. To specifically state one location or another would be hindrance to the officer. As Mr. Smoot said, there's several different options that are available from the product line, but to limit and restrict one location from any other would be more of a hindrance to the officer and your actual data you're recording.
Representative Betty.
Thank you, Mr. Chair and Madam Chair, and thank you, gentlemen on the panel, for what you do every day protecting the citizens of the state as well as your members. One issue to follow up with Representative Rebelletti is, what issues do you think we need to legislate? The reason why I asked that question is because we heard a little bit earlier about the discretion of an officer as to when the camera should be activated. My concern is that if there's broad discretion for the officer to decide when or when he should not or she should not activate her camera, that essentially defeats the purpose of having the camera in the first place. Not only from the perspective of the officer, but also from the perspective of the public. So what do you think we need to be dipping into as far as legislation, and what do you think that we should leave to your respective departments to implement a policy?
Well, if I could, I know that we have a lot of officer discretion already written in a lot of different policies, and pretty much they're performing at that discretionary level where they take necessary action or they respond in the appropriate manner. From when to engage your lights and sirens and when to remove someone from a facility, whether it's a child being abused or a senior being abused, and everything in between. I would suggest that encounters, just about nearly every encounter with a civilian, when you're summoned or when you decide discretionary that you need to approach a situation, a group, or an individual, you engage that camera. And upon learning that it is not going to be anything of nature that you're going to need to take police action, again, your discretion allows you to, disengage the camera. But it's always a tricky call because things blow up in an instant. To keep it on constantly becomes problematic, not only for the storage, but the review. So, to write a policy, I would pretty much suggest that you leave it to the discretion of either the officer or the local agency.
I mean, I certainly understand that, but I think that you would have to agree that there are some bad actors out there. So hypothetically, why would a bad actor, and I'm referring to a law enforcement officer, record himself or herself doing something improper or inappropriate to a citizen? Why would they do that? That would be stupid.
Why would they be acting bad when they know they're on camera as well? Which
and that's
would be,
my point.
Yeah, I don't think that an individual that knows he has or she has to turn that camera on every time they're engaged in a situation where they're talking to the public, it's not going to be something that they're going to be able to not turn on. That they're going to have to follow the policy. If you set a standard that you turn it on when you engage the public, the camera's going to be on.
I think too, if I could just follow up, I think I understand where you're going and what you're asking.
Well, I represent the Englewood community, so I have a unique dynamic that I need to protect and be concerned with.
I understand the challenges that you're facing over there and that the police are facing over there. And so I just would, I understand what you're saying, and I don't think that, I think that the PERF report kind of addresses that and gives departments the ability, or at least the roadmap of how to audit those officers and determine their use of the cameras, the non-use of the cameras, and for the department to deal with officers that may have a misconduct problem. I think you also have to be very cognizant of the fact that officer discretion works a number of different ways. And I don't think anybody in any part of the world that we are working in here would want to discourage officers from engaging members of the community for any reason. And so, I can see the other side of the coin, so to speak. If an officer knows that they have to record or that they're recorded all the time when they're talking to a citizen or having an interaction, they may choose not to engage, and that can lead to even worse problems than I think what you're trying to address.
I would also add that the draft that I've seen with Chicago's potential pilot program restricts an officer from once engaging into a situation from shutting the camera down until that's over with.
But I think if you legislate it too, you also could be discouraging departments from adopting a camera policy at all.
So, I've been handed a case that kind of defines 3 categories of police interactions, and one being an arrest of a citizen supported by probable cause, 2 being Terry stop, and the 3rd being a more broad community caretaking function. interaction, which I guess includes threatening presence, when the officer displays his weapon, some physical touching, and use of language and a tone of voice indicating that compliance with the officer is necessary. I guess within those categories, within each one of those categories, you know, what would your opinion be with regards to what discretion should be used when the camera should be on and off?
I would stick with the policy that I've seen, or the draft that I've seen from Chicago, and until that situation is either determined to be a non-police matter, or until it's over with, if it is a police matter, the camera stays on.
All right. I do see some people here from the city of Chicago, so hopefully this committee could get a copy of the draft of that policy, because we're all ignorant of it. Well, I'll speak for myself. I'm ignorant of it. I don't know, Chairman Nekritz, have you received the City of Chicago draft? All right.
And I would mention to the members of the department that we have a very good relationship, the union does, with the Chicago Police Department right now. And our communication is pretty regular. So I appreciate the opportunity to have seen that draft and to be able to participate in the development of it.
I appreciate that improved relationship. All right.
Mr. Chairman,
yes.
The three examples that you cited, I mean, all three of them, I believe, would warrant the activation of a body-worn camera.
I agree.
Right. Thank you so much to panel.
Thank you.
All right. Next we have the manufacturer panel. I imagine they have some interest in this debate. We have Joe Pioli, VIEVU, and Josh Eisner, Taser International. Thank you, gentlemen.
Good morning. Afternoon now. My name is Joe Pioli. I'm with V.
You'll need to put your microphone on, sir. There's a button on the base of the microphone.
It's green. Oh, thank you very much. Not too good to start out for a technology company, and the microphone's kicking my butt a little bit. Anyways, my name's Joe Pioli. I'm with VView Cameras. VView was created in 2007 by Steve Ward, a former Seattle police officer and SWAT officer. Steve was my partner in SWAT back before he joined the private sector. Myself, when Steve told me what was going on and what he was doing, I'd been involved in different lawsuits as a law enforcement officer. So I just asked how I could be involved. I started working for him in a part-time capacity, and when I retired in April, after 24 years of service in the state of Washington, I came to VView as the director of sales. We have over 4,000 customers using our cameras, about 80% market share. Our cameras are used from sheriffs to police officers on the street. Our largest deployments in Oakland, California, where 800 cameras are deployed on officers. A lot of this information brought up today, previously from Lindsay Miller and the FOP, is spot on. One thing about a camera, obviously I'm selling them, but it's not really reality for you people that would sit back and watch it later. Reality is for that individual, that moment in time that's out there on the streets, when they have to make a split decision under stress. Cameras don't pick up everything that the officer sees, and cameras pick up things the officer doesn't see. So these are all different issues that it's very good that you guys have convened and are looking at. Thank you.
Good afternoon, everyone. Thank you for having me. My name is Josh Isner. I'm the Vice President of Sales for Taser International. I'd like to extend my thanks and appreciation to the chairpersons of today's committee hearing. Thank you, Representative Nekritz and Senator Raoul, for taking the lead to reenact a constitutional and rational eavesdropping law in the state of Illinois. I also want to thank the minority spokespeople on this committee, Representative Sandak and Senator Bergman. It's my hope that we can fashion a bipartisan solution to reenact the eavesdropping law with a specific authorization for body-worn cameras. I also want to express my appreciation for the active involvement of the Illinois law enforcement community. We believe the best solutions are attained when all stakeholders have a voice. So I extend my thanks to the Illinois Sheriff's Association, Illinois Chiefs of Police, the Illinois State Police, the State Attorneys Association, the Chicago Police Department, Cook County Sheriff's Office, the unions, the ACLU, and all the members of active law enforcement here today. As you are aware, I'm here in my capacity as an executive with TASER. Most of you are familiar with TASER as a supplier of less lethal weapons to law enforcement. Less well known is TASER is the market leader in on-officer camera deployments, especially in medium and large law enforcement agencies. In addition to the small wearable cameras, TASER has pioneered an innovative and effective way to store audio and video recordings captured by the officers, utilizing a secure hosted solution with appropriate controls to prevent unauthorized access or tampering. TASER has worked directly with law enforcement and technology experts in developing our technology. The results include longer battery life, pre-event buffering, multiple wearing options for each officer. All of these features result from customer feedback, and as always, we'll continue to gather feedback before developing new products. Recent events in Ferguson, Missouri, and Staten Island, and elsewhere in the United States have served to highlight the critical gap which exists in Illinois between readily available technology to police departments and the legal framework to effectively use them. Across the country, we have seen the call for expanded use of officer-worn cameras, and these cameras have been proven to be a very effective tool in promoting transparency and accountability in law enforcement and in the public alike. In preparing for my testimony today, I reviewed the PERF report in conjunction with the United States Department of Justice, and it highlights most, if not all, of the key policy considerations. So it is a very, very good guideline for any agency looking to implement a body-worn camera program, and we discuss and hear about a lot of these issues in selling and marketing our products. In the interest of brevity, I'll focus on a few issues which are of particular importance here in Illinois. A major consideration to be addressed is who must consent to being recorded. Unlike the federal government and the majority of states in the United States, they are one-party consent states. Illinois is a two-party consent state, as you know. As the name implies, both parties have to consent, not warn, but actually consent to a recording. Because of the societal benefits of the officer-worn cameras, it is critical that if Illinois reenacts an eavesdropping proposal, that there is a specific authorization for body-worn cameras within that legislation. We have heard time and time again that it's impractical for officers to record in every single setting due to the circumstances, and I think Ms. Miller highlighted some of those in the PERF report. And it bears noting that while we favor an authorization of the cameras, we would be opposed to a mandate of cameras for law enforcement, as we recognize that each department should make an informed judgment on their own to whether or not these cameras would be used, and each department is in kind of a different stage of technology adoption, and we realize that others are probably closer to adopting this technology. We've worked with many two-party consent jurisdictions across the country, and we do have some critical observations on kind of the issues in those states. Just earlier this year, Pennsylvania enacted a very similar exception to body-worn cameras, and they are also a two-party consent state. The legislation introduced by Representative Hayes, House Bill 2446, took the simple approach of allowing officer-worn cameras to be treated under the same light that in-car cameras are treated currently in Illinois, and that's a very similar position that the Pennsylvania legislature adopted, in that they would be treated practically the same as an in-car system. With regards to cost, I don't think it's a secret that there are a lot of needs of law enforcement, and they are, at times very under-resourced, and so cost is always going to be a factor in adopting new technologies. One ask would be, in evaluating the cost of these systems, not only take into account the cost of the hardware, meaning the cameras, the servers, the storage, the applications, but also the potential return on investment that an agency will see as well. Some of our models, based on the Rialto case study, which you've heard, show an 88% drop in complaints against officers, 60% drop of use of force. Our models, based on those numbers and others, show a break-even point on the investment within 6 months, and a savings over the long term of $4 for every $1 spent on the technology. So very, very high return on investment for this technology. And it really stems from reduction in complaints, reductions in settlements, reduction in officer time investigating complaints, and so forth. Now, cost also factors into retaining data. The longer an agency must retain data, the more it's going to cost to store data over the long term. We will never kind of recommend a policy to an agency, but there's plenty of good research out there, between PERF and other chiefs of police organizations on data retention. We do see many jurisdictions rely on their city or county prosecutor or attorney's office to issue a recommendation on data retention. Commonly, what we see is about a 60 to 90-day retention period for non-evidentiary video, and about an indefinite period for evidentiary video through the legal proceedings and even afterwards. Now, it is worth noting that in-car cameras, which are a staple of many law enforcement agencies, are about 80% more expensive than on-officer cameras at this point, and only capture about 10% of the police recordings. So this is a really effective way to save costs while increasing the amount of transparency and accountability in law enforcement, as obviously these cameras go with the officers away from the vehicles. Now, in terms of the software, some of the concerns that have been brought up today have to do with public disclosure, the Freedom of Information Act, and redaction. Our software is built such that if data is to be shared, an evidence technician at an agency can actually redact if a minor is in the video, or if there's some inappropriate content, or an undercover police officer. All of that can be redacted in the software before it is released in a relatively easy way. Similarly, there's sharing built in with media agencies, prosecutors, whoever might need the video outside of the department. All of that is integrated in the software and audited all the way through, so that each agency will have an audit trail of exactly what has happened with that piece of video since it's been uploaded. And finally, one of the most successful components of any on-officer camera deployment is policy. Whether it's a body coming together and determining a policy for a large number of departments, or if each department decides on their own policy, having a strong policy is by far the most important consideration when deploying on-officer cameras. In our experience, it usually comes down to 2 or 3 main items. Number one, we've talked about extensively today. When does an officer record? Do they have to record, or can they record when it's reasonable to hit the record button? Number two is the video only used for evidentiary purposes, or is it actually used for investigating police officers for professionalism and so forth? And number three is, do officers review the video before a use of force or afterwards? Do they make a statement before they review the video? And that's an issue that pops up from time to time as well. And those are issues that, regardless of who makes the policy in the state of Illinois, those are key issues, along with the rest of the 33 guidelines in the PERF report. Those are all things to be taken into consideration. So in closing, one thing I would say, coming from the other side of this somewhat with our non-lethal weapons, is cameras are really one of the only things in law enforcement that both the public, civil liberties groups, and police agencies are all pretty much aligned on. There's minor policy things that there might be some disagreement, but with the spotlight on American policing and opinions coming from a lot of different places, to have everyone really aligned on the concept of cameras, it really shows their value and their potential impact on American policing. So I would ask respectfully that you do join the law enforcement community in supporting a specific authorization for body-worn cameras in the eavesdropping law. So with that, thank you very much.
Okay. I figured you would want an authorization for body cameras, but you raised one thing that I should have asked the last panel, and given that you're in multiple states, what is the distinction in policy, or should there be a distinction in policy? I obviously feel that there should be some distinction between uniformed officers and undercover officers, and what have you seen?
In Pennsylvania, for example, it was, the compromise was that it had to be a uniformed police officer wearing the camera, or otherwise obviously known as a police officer, maybe their badge around their neck in plain clothes or something like that. That is a consideration. Some states, it doesn't, the one-party consent states, it's usually not an issue, but states coming from a two-party background, that was a consideration in the Pennsylvania negotiations.
And that was in the state statute or state policy?
It's actually written into the law that the person has to be identified as a police officer.
Okay. All right, and then it was mentioned earlier about circumstance in, I think it was Daytona, or, with regards to an officer that was reporting that his camera was malfunctioning. So how do you, what is it, what quality control or what investigatory process you employ to make a determination that such a claim is valid or invalid?
In incidents where that has occurred, the camera's been shipped back to VView. Our technician logs everything, treats it as evidence, and then function tests it, charging it up as necessary and seeing if it'll record in the manner that the individual described or the way that the individual said it didn't describe, and ensures that it is functional or not functional, and then keeps a log on everything that was done, and then we'll send it back to the agency.
And to add to that, sir, in Daytona specifically, it was sent back to TASER, and we have a group that does technical auditing of our weapons and our cameras, and the camera actually shows when it was manually activated and when it was actually, if it was a cable disconnect or if it was manually deactivated. And in this particular incident, it was something that it was showed to be manually deactivated before or continually at interesting times in a altercation. And so with that data and a pattern of that data, that was what the chief and others used to make their decision there.
And I don't know whether, I'm just thinking hypothetically of all the claims that could come where a camera is off in a situation where it should be on. I imagine one could be that it was accidentally switched off. I don't know how I'm unfamiliar with the cameras and the switch.
Yeah.
How, speak to that a little bit,
I think it's safe to say that both technologies from both vendors, it's a pretty obvious manual process to turn the camera off. With ours, you have to hold a button down continuously for 5 seconds, and it's got a ribbing around it, so it's really got it's not like a seatbelt could turn it off. You have to push it down. I'd say it's a similar manual and obvious process with most cameras.
Regardless of the manufacturer.
Right.
Senator Hastings.
Gentlemen, thanks for coming. I represent the greater southwest suburbs of Chicago, so I know we have some of our police chiefs here as well. My question is in regards to the product itself. Can the product be remotely accessed in terms of the chief at the police station wants to activate the camera on the police officer?
No. No, our camera is made so that it'll be activated by the individual in the field. So the officer would follow the policy that the department has set on when to activate it and under what circumstances to activate it.
And then my second question, is there a capability to add on GPS onto the system?
Not with our system, no.
So to answer the last two questions, right now there is a live viewing feature within our camera within 30 feet that can be streamed to a phone or tablet to be able to review. Like if you put the camera on a canine that's going to search a house, you could actually see the stream of the video. The next step will be doing that over a 4G or Wi-Fi network. So that is partially there right now, but not all the way. And then as to the GPS, that's, again, our device is enabled to do that, but again, it's a policy issue for each department. You can, an admin in the agency can either dictate that the GPS would be turned on or that it wouldn't be. And if the GPS is turned on, it's not like a supervisor could pull up a map and see where all the units are. It's more, once you hit record, it'll take the latitude and longitude and keep those figures. So on a map after the fact, you can actually see where the recordings and events happened.
So you do have a pre-event recording capability then?
In ours we do, yep, it's 30 seconds.
30 seconds. Is that automatic or could that be adjusted by the police department?
It's either 30 seconds. Right now, it's not concrete. If an agency has to have it longer, we could do that in the software, but generally we hear 30 seconds is fine. You can actually turn that off if you want, so it just starts when you record. It's important to note that 30 seconds, though, does not have audio. So if the officer is having a conversation or whatever might be going on, it's only the video once they hit record that is backtracked, and then once they hit record moving forward under normal circumstances, it would be both audio and video from that point on.
Okay, last question. In terms of backup capabilities, how do you guys, is it like a loop that it continually stores? How does that work?
Yep, so for ours, it's a 30-second loop that writes over itself, and then when you hit record, it actually stores the previous 30 seconds to memory, plus whatever happens from that point moving forward.
Thank you very much, guys.
So it's looping every 30 seconds, and that's how you can capture the last 30 seconds before.
It varies by manufacturer. With ours, it loops every 30 seconds.
Does yours do the same?
No, ma'am. We sort of looked out for what was described as privacy and such. With our activation, it starts after it's been moved down, so you don't have any of the pre-records, so you don't have the situations of contacting an undercover officer, informant, cooperating witness in the street that may be giving you that information, activate, and then have them recorded.
And then my other question is, concerned about this whole ability to know, to sort of monitor when the officer, if the officer is complying with policy about when they're turning the camera on and off. Can you tell the time of day that the camera has been turned on, and can you keep track of it that way? So if there's an incident reported and you know that the officer didn't turn the camera on, then there's a, the data doesn't match up, that there's ways for the department to track that?
So the answer to that is yes. We have an integration with the records management and CAD system that an agency uses. So it actually matches up officer videos based on badge number to a recording. So if there's 5 calls for service that an officer was on and there are no recordings that would match those times, then it would be pretty clear that that there was a pattern of not turning it on. I'd say overall another trend in the industry is moving forward into the next couple of years across the industry. I think you'll start to see more automatic activation features, meaning officer turns the blue lights on, it would automatically activate the camera. Officer activates a taser, for example, could automatically activate the camera. So those types of features, and again, I don't think it's only taser. I think everybody across the industry is looking at that type of feature to kind of prevent the types of incidents where an officer forgets to hit record and so forth.
Right, but right now you could by time of day you could audit if you needed to. All right.
Yes, ma'am.
Senator Noland.
Thank you, Madam Chair. Now, I may have missed this in your testimony, and I apologize, so if I'm asking something that you've already covered, but 2 questions. Number 1, do you have, and are there agencies that are implementing real-time observation of officers that are out in the field? In other words, is there somebody back at the station that's watching 24 different officers out in the field at any one time, and that are recording real time, or at least videoing, if not taping, real time?
No.
No? Okay.
So the live streaming feature is
Live
still
stream,
probably a little ways away in terms of the technology.
A little far afield from what we're doing here. Then also, too, can you tell me, we talked about the loop back, 30-second loop back, okay, in the instance of Taser. Your technology, you say you don't do that, and is that a policy or decision that your company made, you know, to answer market demand? Or
yes, when we came out in 2007, our thoughts being police officers realized that when we activate it, there's all kinds of circumstances that could occur before, such as with the in-car camera system. You always can think of that because you're parked out there on the road and you don't go into private locations where there are locker rooms, bathrooms. If you just went into a restaurant, you went in to use the facilities, and when you came out and you saw a disturbance, you activated your camera, you would then have your previous experience back there in the restroom. Yeah. So those are the types of way we're thinking. Also, if we're flagged down by a citizen in the street that wants to report a crime, their privacy. If I activate my camera, I've got them recorded. So those are things we've taken into consideration.
And this is a question for both of you regarding the technological capabilities of your platforms, what you have to offer. How far back could we go? You know, and if it's not just 30 seconds, how far back could we go? And what have some departments, you know, chosen to do?
For our technology, theoretically, you could go back a few minutes if necessary. We usually think the 30 seconds, and what we've heard is the 30 seconds is plenty. We kind of base that decision based on what in-car systems do. And the reason, take a step back with Taser weapons, they were relatively, there was a time when their uses were relatively controversial, and so the power of context with a video we found was really important. And so to be able to backtrack to show why an officer turned the camera on was, you know, a really important element of showing what the officer is faced with, such as a citizen comes up and pushes a police officer and so forth. To be able to hit record and actually backtrack and capture that, I thought was really important to paint the picture and to show the context of why an incident had happened.
Before Mr. Pioli, you respond or you inform us what your company's technology can do. What are you saying you can do? I understand you go back 30, I understand the reasons why, but what are you capable of doing?
I mean, the software can be written. If there's a requirement for 5 minutes, it can be done.
2 hours?
2 hours, yeah, I mean, it can be done. The trade-off is the battery life. If you're actively recording and storing that much at one time, then, you know, our battery life goes from 12 to 15 hours, probably cut in half. And so the thinking is, you know, to balance the amount of battery consumption with the context type of element.
What you're doing.
And I think the unions have had some input on that as well, on what the best practice would be.
Gotcha. Sir?
And with our product, we don't do pre-record, so we aren't going back.
Do you have the capability?
No, not on our current things, but what we always do is take feedback from customers and look at things that we want to do in the future.
Very good. Okay, thank you very much.
Right, thank you, gentlemen, very much. Appreciate the inputs, very helpful.
Appreciate it.
So our next panel will be the law enforcement panel.
Master Sergeant John Thompson on behalf of the Illinois State Police. The Illinois State Police has always supported the philosophy of audio-video recording the encounters that we have with citizens on a daily basis. Conceptually, Illinois State Police is in support of the use of body cameras. I would say I would withhold a official position on any legislation at this time until we see the final language. But conceptually, again, we do support the implementation of body cameras. We have found with our in-car cameras that they are an excellent tool. They're objective. They determine exactly what happened at an event. With many of our interactions being posted on online media, we believe that law enforcement should have the right to capture unedited versions of the event from the real start to the real finish. Cameras increase officer safety as well as reduce the number of citizen complaints. They enhance officer and community safety and improve collection of evidence for investigative purposes. Without having actually used a body camera, I am familiar with in-car cameras and have used them my entire career up until my recent assignment in this office. And I believe that those cameras do provide insight as to what we could probably expect from use of a body camera. You know, a little historical perspective, ISP began using in-car cameras in the 90s. They were actually provided to us by MAD, Mothers Against Drunk Driving, as part of DUI enforcement. Then, fast forward to 2008, the Illinois State Police codified our policy in law, and we are required to have in-car cameras in our patrol cars. All frontline patrol cars have an in-car camera, and that's required by statute. Based upon my own experiences, and like I say, I have a unique perspective. I've used in-car cameras before. I always viewed the in-car camera as my friend. It was my second set of eyes. It protected me against allegations. You know, just a couple examples of things that I would do as a routine. You know, it's not always safe to stand between vehicles on the interstate, but when I felt it was safe, I always conducted my pat-downs and search, particularly of females, in front of the camera. I would articulate my stops with my camera. You know, I would articulate the cars moving over the center line, the cars moving over the fog line, it's driving on the shoulder. You know, on the side of the road, state troopers are allowed to take cash bond for citations. I always told the citizen, I said, count the money to me, I count the money back. I would say, for my safety and yours, this stop is being recorded. If you feel that, you know, something's suspicious here, you can contact my supervisor at headquarters, but this is all being recorded. Never had any complaints, never any question about taking a cash bond on the side of the road. I would show evidence to my camera, PBTs, a portable breath test as part of a DUI arrest. You know, when the citizen would blow into the machine, I would show the reading to the camera, because sometimes I would forget what they actually read, but it would also show a little transparency. My LiDAR, my speed gun that I used, I always try to make a habit of showing the actual speed on the LiDAR to the camera. Again, transparency. I've put everything in as far as pill bottles, saying don't mix this with alcohol, don't, you know, operate heavy machinery. You know, I used the hood of my car was a stage, if you will. I put everything, beer bottles, vodka bottles, drugs, guns, everything on the hood of my car right in line of that camera. It also made my performance of standardized field sobriety better. You know, all of our videos have a second counter. And if you're familiar with DUI field sobriety, you know you have to do certain tests, certain amount of seconds. You know, there was a time where I realized I was cutting some things short, you know, and arguably that gave the citizen a fair shake in court that, you know, that the officer wasn't doing something right. But that made my job and made my performance better. You know, when I first started using my camera, I would actually set the camera to record the probable cause. Again, you know, nowadays, as you just heard, these cameras are actually rolling back, capturing this footage. You know,
Sergeant Thompson, I don't mean to cut you off, but okay. I think we get it. So I don't know if you've got recommendations or
the only recommendations that I would offer to the committee, as far as you know, we want to avoid an unfunded mandate. You know, we need to decide. We need to have the power to decide what officers need these. You know, not all police officers need to wear one. I don't think in my current job duty, I need to have a body camera on. I mean, we need to, you know, put them to the officers that actually will benefit from them. You know, again, you know, unfunded mandates. I mean, we don't want to move away from video cameras in the cars. You know, the analogy was presented once to me. It's like when you watch a football game on TV, would you rather watch it from the field view or would you rather watch it from an individual football player view? There is still good benefit of video cameras in a car, so we would like to continue using those and start slowly implementing body-worn cameras, and in the essence of time.
Thank you, I appreciate it. Sheriff?
Members, thank you very much for this opportunity. My name is Pat Hartshorn. I'm the Sheriff of Vermilion County, Illinois, and I'm here today representing the Illinois Sheriff's Association. As we've heard many speakers here today state, scores of law enforcement agencies already use body-worn cameras, and calls have grown across the United States for more use of them after recent cases involving use of force that has pitted the word of police officers against angry citizens. Police departments, large and small, across the United States have launched pilot programs to test cameras for wider deployment. By equipping police with such devices also raises new and unsettled issues over privacy at a time when many Americans have been critical of the kind of powerful government surveillance measures that technology has made possible. For many departments, questions remain about when officers should be allowed to turn off such cameras, especially in cases involving domestic violence or rape victims, and to the extent this footage should be made public. Police videos have often captured people in their worst moments, and is it right for that one instance to be plastered across the internet for everyone to see? Where is the public good in this type of sensationalism? Footage from dashboard cameras, which have been in use for years in police cars, are more widely used technology and have long been exploited for entertainment purposes. Internet users have posted dashboard videos of arrests of naked people on YouTube. TMZ sometimes obtains police videos of athletes and celebrities, public figures, during their minor and embarrassing traffic stops, turning officers into unwitting paparazzi. Officers wearing body cameras could extend the public eye into living rooms or bedrooms should a call require a police officer to enter a private home. Faced with these challenges of striking balance between transparency for police and privacy for citizens, U.S. law enforcement agencies have not adopted a uniform policy for body cameras, which come in various sizes and can be worn on shoulders, on glasses, and on lapels. In the diversified world of local law enforcement, a one-size-fits-all uniform policy would be difficult at best to implement. A policy report released last month by U.S. Department of Justice and the Police Executive Research Forum, who you've heard today, suggested body-worn cameras help police departments ensure events are also captured from the officer's perspective. Sheriffs who support body camera technology say that both officers and citizens behave better while being recorded, and that with the cameras, complaints against police officers have declined, with video often but not always supporting the officer's side of the story. The sheriffs of Illinois believe that there are a number of considerations that this committee and the legislature should give due diligence. Number one, policies and procedures for recording. It is imperative that officers are clear on when and where they are required to record and where there is discretion, such as crime victims, witnesses, informants, as an example. Retention, a clear-cut policy that determines the length of time recordings must be retained, especially those recordings that did not require further police action or arrest. 3, equipment and data storage costs. Although cameras are relatively inexpensive in comparison to in-car systems, they will ultimately, based on departmental policies, collect much more video. The data storage can become quite an expensive undertaking that most law enforcement agencies do not have the budgets to absorb. Officer training. Once implemented, the body-worn cameras will have to become second nature to every officer wearing one. Training will be a paramount to a successful program that not only brings transparency to the process, but ensures that the public understands and embraces the program. 5, the Illinois sheriffs believe that whatever decision the committee comes to, that the legislation should be permissive and not mandatory, so that each department and each community in Illinois can decide at what level they want to deploy this technology. 6, serious consideration should be given to a legislative exemption to the Freedom of Information Act for videos that are captured on officer-worn body cameras. At the very least, it should consider a release signed by those that have been recorded if the information is released to the public. 7, the Illinois Law Enforcement Training and Standards Board should be given the responsibility to develop a model policy which can be used by all law enforcement agencies in Illinois. The policy could be used as a minimum standard or could be built upon by the individual agency into a much more restrictive policy if they so desire. The training board should also be given the responsibility to do research in developing best practices from across the United States on the use of body cameras. With the responsibility given to the Illinois Law Enforcement Training and Standards Board, there needs to be a mechanism for funding that can allow them to train officers, do research, and develop policies. Senate Bill 3911, Amendment 1, is a vehicle for such funding to allow the training board to carry out these tasks, and the Illinois sheriffs support that legislation. Thank you very much for your attention.
Thank you. Whenever you're ready.
Thank you, Chairman Nekrich and Chairman Raoul, for allowing us to participate in this hearing today. I'm Chief Fred Hayes with the Elwood Police Department. I'm currently the president of the Illinois Association of Chiefs of Police. With me this afternoon is Chief Terry Lemming from the Lockport Police Department. Both of our agencies are in the prospering county of Will, just south of Joliet and east of Joliet. As the president of the Illinois Association of Chiefs of Police, I represent 1,200 members that are representing over 900 organizations throughout the state of Illinois. Not to revisit a lot of things that my colleagues have said today, I'll make my comments very brief, but you should hear from the Illinois Association of Chiefs of Police. We have made this, the use of body-worn cameras, our #1 legislative priority. We feel strongly that the use of this technology is the next logical progression for the use of cameras in the state of Illinois. We really feel that the use of dash cam videos, if you will, or in-car video cameras were a great starting point. And to refresh your memory, as the Master Sergeant said from the Illinois State Police, they were originally used as an evidentiary device to capture evidence of DUI impaired drivers. Certainly with the progression of that technology, it has also opened the eyes to the public so that we can actually view what is actually occurring inside a law enforcement agency, and it's opened the window for a lot of the community to see what's going on. And certainly we think that it should progress from the dash mount system to a body-worn system. Our view is that the legislature should focus its attention on allowing law enforcement the exemption in the eavesdrop statute so that we may use these pieces of technology. And secondly, the General Assembly should focus its attention on addressing the privacy considerations and concerns that are being raised by the community. Certainly, it is our view that officers should have the ability to operate video cameras while inside the residence of a private individual if the officer has a legal right to be there. However, we feel that the disclosure of that video to the public would be an unnecessary and unwarranted violation of their privacy. It should be used only in incident-driven concerns raised by the owner of the residence or the person that has that expectation of privacy at that location. We feel that the adoption of policy on the use and implementation was very well stated today by the Police Executive Research Forum. As you're probably well aware, many of our members are members of PERF. I'm a previous graduate of PERF's Executive Management Institute in Boston University. I really think that PERF got it right in this study and in this research. The last Illinois Chiefs Association survey, which was done just a few years ago, we reviewed our organizations, the 900 organizations that we represent throughout the state of Illinois. And believe it or not, only a little over 50%, right around 58%, are using in-car video cameras in the state of Illinois. There are still some obstacles out there. Funding certainly is one of them. As you've heard today, typically in-car video camera system may cost as much as $5,000. These body-worn devices are significantly cheaper, ranging anywhere from $800 to $1,200. But certainly then we also have the unique situation of data retention and data storage. I bring the unique perspective as a small-town police chief with a department of only 10 members, But my previous position was the chief of police for the city of Joliet, where I had over 300 officers and a community of 150,000. Chief Lemming, although now represents 38 officers in the city of Lockport, is a previous lieutenant colonel with the Illinois State Police. So we recognize that a cost-benefit analysis needs to be done individually by each department. And finally, I must tell you that the missing video presumption keeps me up at night. I think a lot of my colleagues don't realize the impact of that ruling yet. It's case law that is just starting to filter down. To make it clear to my colleagues, I do understand that the case law is pretty punitive to law enforcement and not allowing officers direct observation testimony when the use of video equipment is present at the scene, and for some reason, it's not being made discoverable or presented. And certainly, this ruling, or this missing video presumption, is a concern. I will tell you that using this equipment, it's Murphy's Law. There's a lot of situations where there's technological failures that occur. And certainly, I think you heard from the vendors today talking about the different abilities and capabilities. As I heard the hearing today, the questions about GPS tracking, the question about loopback and retention, all of that technology currently exists in in-car video camera systems. It's here. We are using it. What we're looking for is the legislature to allow us to advance that. I think it's a benefit to the officers, and I think it's a benefit to the people of Illinois. Terry?
Good afternoon. My testimony will take less than a minute, which will probably make me quite popular. We're here to talk about body-worn cameras, but we're really not. It's really body-worn audio. That's what it's really about. Senator Raoul had asked earlier the PERF representative if we had any state model laws. And the reason we don't is because most states don't have a strict eavesdropping policy, as Illinois has had for the last 44 years. I just wanted to point that out regarding our law. It's really a audio issue, not a video issue. Anybody can film anybody in a public place video-wise. It's the audio portion that we're talking about today. Thank you very much.
Good afternoon, ladies and gentlemen. My name is Valerie Salmons. I'm the Vice Chairperson of the Illinois Law Enforcement Training and Standards Board, and it has been my pleasure to serve on that board for the last 25 years. In my real life, I'm the village manager for the village of Bartlett. Last spring, the board, through our executive director, Kevin McLean, approached Representative Jehan Gordon Booth and subsequently Senator Bill Hayne to consider an amendment to House Bill 3911, commonly known as the camera grant. To date, this bill has provided funding that allows police agencies across the state to install video cameras in their patrol vehicles. Director McLean and Representative Gordon Booth crafted an amendment that would allow for the funding of body cameras to be worn by police officers as they conduct their business. The board strongly believes that the addition of these video and audio recording devices will dramatically improve both officer safety and public safety. Although a relatively new innovation, the use of body cameras by police agencies in other states, as you have heard, resulted in fewer complaints against police, a reduction in the number of use of force incidences by officers, and a stronger feeling of trust in the police by the public. And so I believe this is a wonderful opportunity for the state to move forward with one of those very hard to accomplish win-win situations. House Amendment 1 to to the Bill 3911 provides a funding mechanism. We've talked about that repeatedly this morning. A funding mechanism to continue funding in-car recording systems and also to make that same funding available for body cameras. The amendment also removes a sunset clause included in the original legislation, enabling my board to receive new camera applications. The additional monies will be used to fund this important program and to provide training. We've talked about that repeatedly, and the key to success of this endeavor clearly is training and, importantly, research. The training board each year provides basic training to all police recruits through 6 certified police academies located throughout the state. Comprehensive training on a wide range of police topics is provided to over 40,000 police officers throughout the year through our board's 15 mobile team units that are throughout the state of Illinois. The board also partners with the University of Illinois to provide academic research into police training issues and needs. And in 2016, that partnership will unveil a new 560-hour curriculum for the recruits at the academy level. Additionally, research into the use and resulting data gained by these cameras will be conducted to optimize the advantages of using these recording systems. The board commends Representative Gordon Booth and Senator Hayne for their sponsorship of this important legislation. These cameras will show all concerned people and agencies what took place between the officers and the members of the public. These devices will let us all know the truth and thus improve the relationship between police and the public. My board would like to thank the following organizations for their strong support of this legislation: the Illinois Sheriff's Association, the Illinois Association of Chiefs of Police, the Illinois State's Attorney Appellate Prosecutor's Office, and state's attorneys across the state of Illinois, and the NAACP. I appreciate your time and your consideration of these really dual issues. First of all, the cameras in and of themselves and all of the attendant issues that go along with that, and also for the proposed funding mechanism that I have briefly laid out today. Thank you.
All right, so there's been some mention of model policy. I mean, Representative Gordon Booth and Senator Hayne have been dealing with the funding issue. I don't think that's really our mandate.
Well, I just thought I'd throw that.
No. I mean, I'm not faulting you for mentioning it. But I think what we're really trying to drive at here is, what if anything we put into an eavesdropping statute with regards to speaking to officer-worn cameras, and there's been some mention of model policy and that we just set out to say that there's going to be some model policy, and our work is done with regards to the eavesdropping statute. I don't know what comfort individual members have with that. So we've heard a recommendation with regards to FOIA, but with regards to on and off and some of the other issues being raised, are there any recommendations that maybe broad recommendations that still allow for more specific policy to be determined at either with the model policy or at the agency level, but give people more comfort, given that it's been recognized that Illinois has been, and it's even in our Constitution, a state that has a more heightened sensitivity to privacy.
let me answer your question. I don't know if this will provide you with more comfort. There have been 2 recommendations so far that the Illinois Law Enforcement Training and Standards Board put together a model recommendation. We have done that many, many times over the years. Done that way back when we started the pursuit vehicle policies many, many years ago. And in order to accomplish that, we do put everybody at the table who has any kind of stake in this issue, and so that those details you talk about aren't out yet. But they will be out. They will be vetted at length during the process of developing this model policy, and I think that that makes good sense to move ahead and do that.
And then once everybody's at the table, does that policy revisit us, or is that policy just, because, you know, it's one thing, I've been at many tables where I was at the table, but I didn't like the result.
Well, for people in your position and people in my position, the answer is yes, absolutely.
Senator Nolan.
Thank you. Madam Chair, Mr. Chairman. Chief Hayes, I want to make sure that I understand you clearly and that we're on the same page here. With regard to the missing video presumption, I'm going to confess, I'm not aware of any existing case law in the state of Illinois that implements it as, or that a judge has entered a finding or ruling on with respect to my understanding of the presumption. Can you direct us to? And
yes, sir. I apologize. I don't have the case site with me right now. There is a recent Illinois Supreme Court ruling on a case involving a motion for discovery where the law enforcement agency was unable to provide the video from the incident. The agency had certain claims of why they weren't able to produce it, but the ruling from the court was because they were unable to produce it, that the direct observations of the law enforcement officer at the incident, during when this video should have been capturing the incident, would not be allowed as testimony.
It was inadmissible?
Yes, sir.
Okay. And that troubles you?
Yes, sir.
Okay. Why?
It troubles me because there are going to be incidents where individuals have a legitimate reason why the technology did not work. I've been working with this technology for many, many years. I was reminded by FOP Representative Keith Turney earlier this afternoon that in 1983 I was one of the first police officers on the Joliet Police Department to bring a video camera on duty and record police interactions. Didn't have the foresight to develop the cop show or, bring it out to YouTube at the time. But what I've learned with extensive involvement in electronic surveillance is that the technology does fail. And it fails at sometimes during the worst possible moment. Okay. I can tell you of a case where I had an eavesdropping order. I was doing a homicide investigation. Recording the defendant secretly based on the court-authorized eavesdrop order, and the audio recording failed, never captured the incriminating statements from the individual. So this ruling does trouble me. There are going to be incidents, legitimate incidents, where the officer's technology, the equipment fails, but this ruling would prevent them from actually providing their direct testimony. I really think that that's a movement in the wrong direction. I understand the punitive ramifications for the failure for them to disclose the information. And I do understand that there needs to be some ramifications when agencies fail to comply, but it does trouble me.
I appreciate that. Can you tell me what municipality or what law enforcement agency was involved?
I'm sorry, sir, I don't recall the municipality.
We'll follow up.
I promise to get it to you, though. I will deliver that case ruling for you.
Very good. Thank you very much.
Thanks,
Appreciate
Senator.
that. Thank you, Mr. Chair.
Representative Raboletti.
Thank you, and thank you, Chief Hayes and Chief Lemming, for being here, for all of you being here. Again, I asked the other panel about some of the concerns that your departments or your agencies may have. Is there any particular time that you believe that the camera should be on. And let me address Senator Nolan's concern. Having been a prosecutor in cases where the video or audio did not work, I believe it's up to the finder of fact to determine the circumstances as to why the audio or video wasn't working at the time. So if the jury wants to believe that the police were somehow not being forthright and they shut the thing off when it shouldn't have been shut off, let them find the person not guilty, or the judge can do the same. So I don't think you throw the baby out with the bathwater, because technology doesn't always work. So again, what are your thoughts on when the camera should be on, that we don't have this gray area of just a casual encounter on 4th Street and in Joliet versus now it's not community caretaking, we're now off to a retail theft investigation? When should that camera be on?
I really believe that we just need to extend the ability of officers to use that technology. An extension of the current legislation and the in-car video camera, and the extension should be allowed for law enforcement-related activities. We've outlined, as you've heard today from Police Executive Research Forum, exactly what that definition is. And you know, a clearer a subcategory of law enforcement-related encounters or activities would be traffic stops, arrests, search, reasonable suspicions, or of what we've talked about earlier, Terry stops. Those incidents, the equipment should be on. Certainly, there needs to be a level of discretion. I don't think that the legislature is going to be able to come up with the bright line rule. That discretionary measure would have to be allowed to be set in policy by law enforcement agencies.
And that's what I was hoping that we would be able to elicit from you, because it will leave that, again, leave that up to the finder of fact, we'll leave that up to motions to suppress. We'll deal with that in the court of law, because I think at some point we can't micromanage every instance in which that camera should or should not be on, and that can be argued in the different branch of government than us. Any other recommendations that you have or thoughts on funding or anything else? I know we're not necessarily talking about funding, but what else we should be doing?
Yeah, funding's always going to be a challenge, and you know, that's why you're hearing from law enforcement that we don't feel that this should be an unfunded mandate. Just to give you a real quick example, my department has 8 officers right now. I have 1 in-car video camera system. I am working towards increasing that to all the cars that are out on the street, which is a maximum of 3 during any particular shift. I have to first purchase a server, data storage server at $9,000 to hold 18 terabytes of data. 1 in-car video camera system right now is capturing about 1 terabyte of data in a 12-month period. So retention and storage have a cost effect. When I was in the city of Joliet, I purchased 60 in-car video cameras at a cost of $250,000 just for the in-car video cameras. The video storage system was getting very close to $1 million in annual maintenance costs for that system. So it can be very cost prohibitive. Having said that, I think the role of the legislature is to allow us to move this technology forward, recognizing that we do have some challenges as far as costs, and recognizing that there is no bright line rule about when it should be turned on or turned off, but we certainly can develop model policies on a local level to respond to those concerns.
Thank you.
I want to get to this bright line rule, because it intrigues me a little bit.
Yes, sir.
I understand the testimony of, I forgot the first witness, that there are variances in department size and budget and things of that nature. But notwithstanding those variances, there are going to be some commonalities in all departments, and to the extent that there are those commonalities that may impact the policy that may be implemented as to when a camera is turned on or off, it would occur to me that there would be some bright line rules that could be and I don't know that because I'm what they are, and I'm not a law enforcement officer. I've prosecuted before, but I'm not. You know, I wouldn't hold myself out to be somebody to individually determine what those bright line rules are. But it would occur to me that there are going to be some areas where there would be bright line policies that could be implemented statewide. As I mentioned before, we are, for better or for worse, a state that values privacy, right? And that distinguishes us from many states nationwide. And for my part, I don't, you know, I'm proud of that. And I'm not saying that overnight, you know, within the next month or so that we can come up with that. But given that there's this notion of the, oh, I forgot who you are, but the Police Standards Board coming up with policies in the past, it occurs to me that there would be some bright line rules that can be implemented statewide that the legislature could embrace after being so informed. Would you agree or
Well,
disagree
sir, let me
with
clarify myself a little bit there. What I mean by the bright line rule, I don't believe that the legislature is going to be able to legislate all of the considerations that we have spoken about today in your role. Certainly, we do understand the considerations for privacy, and we're actually recommending that the legislature really look at those privacy considerations and consider legislating those issues. Certainly, when video is recorded in the privacy in someone's home, we don't feel that that should be available for public disclosure. So we would ask that the legislature consider that very carefully because that is our concern also. There are other situations, you know, sensitive situations where video may be captured that would not be necessarily of value to the community to see. A quick real example of that I might offer is that I had an officer on the midnight shift about a year ago with our brand new in-car video camera system who was on routine patrol at 2 o'clock in the morning and captured a male adult walking down a rural street wearing a diaper. And upon further investigation, this was all captured on in-car video camera system, this individual was suffering from a mental illness. And certainly he needed to get treatment, and we saw that that's exactly what took place. But now this is a public record, this capturing of this sensitive situation that occurred. And in a situation like that, you know, how does the legislature respond to situations of privacy concerns when you have situations like that? I think in the home, in the privacy of a home, it's a lot easier, you know, to balance that and perhaps even legislate that, which we encourage you to do. But I also believe there's going to be other situations where we're going to capture video that doesn't necessarily need to be shared with the members of the public.
Yeah, and I appreciate certainly the sensitivity of sharing it with members of the public, but there are other considerations that may not touch that, you know, that may touch, you know, the probative value of whether, you know, there's been excessive force and things of that nature. That certainly there's got to be some system-wide bright line rules about that statewide bright line rules about that we can embrace. I know there are some more granular details that it doesn't make sense for the state to try to address every possibility out there, but there are some broader topics where certainly I would imagine that we can address those things at a statewide level.
Sure, and certainly as we look at that, I mean, we're proponents of use the technology, a policy that requires the use or requires the activation of the equipment in those encounters that I mentioned earlier, traffic stops, arrests, searches, what have you. Certainly the policy should be required in those situations. And I think you've heard from the vendors today, and you can hear this from law enforcement agencies, the policy and the technology allow police administrators to review and to determine whether or not officers are abusing their authority and maybe not accessing the equipment when they should be. We have those policies in place right now for in-car video camera systems. We have the technology to determine whether or not they were manually disconnected, whether or not they weren't used when they were required to be used. There's a lot of tools out there on the technological side that are now available for us to really on a local policy level ensure that the equipment is being used. Certainly, as I heard members of the FOP speak a little while ago, I understand the concern of rank and file. I did come from that environment at one time in my career, so I do understand the concerns of the officers. I've actually seen some pushback already in collective bargaining agreements, particularly when it comes to random access of this kind of data and information. Many officers aren't so concerned about incident-driven complaints or incident-driven investigations as they are concerned about random audits of this information. And as an example, in my department in Elwood, we just recently signed a collective bargaining agreement that prohibits the random auditing of electronic data such as video camera. The audit or the viewing by supervisors has to be incident-driven. And certainly on a local policy level, you know, the issue of whether or not that camera was activated, I think the individual agencies have the ability to address those concerns. And I think you will hear from the Illinois Chiefs Association that we strongly encourage the use of the technology and the model policy that requires activation with limited exemptions for discretion of when the camera should be shut off.
Yeah, you anticipated my next question, that it was going to be about, you know, notwithstanding the new kumbaya between the city of Chicago, the city of Chicago and the FOP, Lodge 7. I imagine that there's going to be some issues in collective bargaining revolving around this, and I dare be the person to ask the question whether, I mean, there's some issues that are best left the subject of collective bargaining, and there's some issues that may be best left for implementation of a statewide policy. You know, are there, you know, is there any suggestion of what is what with regards to this topic?
Again, Senator, if I would state clearly to you and the legislative body that I view your role as allowing law enforcement the exemption in the eavesdrop statute to use this technology. Currently, previous to the Supreme Court ruling declaring the eavesdropping statute unconstitutional, we did not have the ability to do this. The exemption was specific to in-car video cameras conducting traffic stops and investigative stops. So, you know, we recommend that the legislature strongly consider allowing an exemption to further expand that use of technology, and then certainly guard the privacy considerations with a close look at the FOIA statute to ensure that individual privacies are protected, and then finally leave the implementation and the utilization of this technology to the local level for policy implementation and deployment of the technology.
So that means everything else would be left to collective bargaining, or?
Well, as you know, Senator, each one of our agencies has to wrestle with collective bargaining, you know, on a pretty regular basis. And this issue is, like I mentioned, has become a topic of collective bargaining. And I do view it as something that you will see on a collective bargaining level in the future. It's something that the legislature then could take a step back and look at what are the results of these collective bargaining agreements and where is this progression going, and then perhaps then make some adjustments based on that.
All right. Thank you. Thank you to this panel. I appreciate your testimony. We're going to combine, because they're always such good friends, we're going to combine the state's attorney panel with the ACLU, because I think everything they're going to say is going to be identical. So.
Closer than you might think, Mr. Chairman.
All right. We'll start with the state's attorney.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. My name is Matt Jones. I'm with the State's Attorney Appellate Prosecutor. With me is Pat Coughlin from the Cook County State's Attorney's Office, who has taken a lot of time and effort to look at these issues in depth and identify some legal issues as well as some implementation issues. I'm going to talk about a couple of broad overview points and then let Pat take over, and then we'll be happy to answer any questions. First of all, the prosecutor community broadly supports the use of body cameras because we like solving cases and doing it accurately. We think that the body camera is the best evidence of interactions, and we have long advocated both through the eavesdropping statute as well as through the use of these body cameras for the best evidence available to get to the truth. And that's the video and audio depiction of those interactions. Obviously, this is a complex issue which requires a balancing, and with all due respect to some other speakers who've spoken before, I'm not convinced that the law today would allow for the use of audio and visual under the absence of an eavesdropping statute. Section 6 of the Illinois Constitution is broader than the Fourth Amendment principles enunciated in the U.S. Constitution. It goes beyond eavesdropping to other means, and so therefore I think we do need to be very thoughtful about enacting an eavesdropping statute as soon as we possibly can that, from our perspective, balances those rights of law enforcement and the public, and we think that a body camera bill is an important part of that, again, to achieve that best evidence. You also have to balance the interests under the Fourth Amendment of law enforcement officers who, just because they put on a badge does not mean that they lose their personhood. They have a right to have a necessity break and to have food, and even while they're within work hours, to have some sense of privacy in some of their communications and conversations. That being said, when they're interacting with the police or with the public in an arrest situation, in a Terry stop situation, as the case identified in a community care situation, they currently go through an analysis as they interact with the public in terms of what role they're playing, what level of suspicion or evidence that they have. And I think they make those analyses every day. They know when they have achieved the point of a Terry stop in their own mind. They know when they have achieved probable cause in their own mind. The concern, and I think there's a broad concern that we want to make sure that we are over-inclusive rather than under-inclusive to make sure that we're promoting transparencies. And as I think they would acknowledge, you can't often tell when you come up upon a scene whether you're in a community caretaking role or whether you are in a how quickly you're going to move to a Terry stop or a probable cause situation. That being said, the other part of this, if you're going to balance this, and I think the ACLU made this point on the drones bill so crystal clear that technology does change the analysis, and that technology can become much more invasive, even though conceptually it's very similar to what we've done in the past. So the video, the power of the video is incredibly important, and protecting victims from the public disclosure of otherwise legitimate interactions with the police cries out for changes to the FOIA statute. I would say that if you don't protect the public from disclosure of innocent communications, innocent contact with the law enforcement, then you have done a disservice and made things worse than they are today. And I think things are not great today because of the absence of a statute. So must do FOIA reforms, must do eavesdropping in order to implement this, and you must provide a balance. The community caretaking function is defined in the law. You know, perfect example is a law enforcement officer comes up on the side of a road and somebody has a flat tire and they seek to help them change the tire or get support for them. The problem, as we have seen, is they go pretty quickly from that to they have probable cause to think that this car with a bad tire suddenly is transporting drugs. And so it goes from one status to the next. So I think that's critically important. One other thing I want to touch upon, and then I'm going to let Pat talk. There has been a discussion of protecting not so much privacy rights, but First Amendment rights. And there's to some degree, a conflation of those. I get the desire to protect First Amendment behaviors from the chilling effect of this new technology in the hands of law enforcement. And the fact that, I say it is not a privacy issue because if you are protesting in Grant Park, the purpose is to communicate to the public a message. That's, you are assembling, you are communicating. And so the TV cameras are there because you want them there, you want people to hear you. So it doesn't implicate, in our opinion, privacy interests. It does implicate First Amendment interests, and that's an important distinction both legally and policy-wise. I think it is very difficult to draw a line, and had some brief conversations with the ACLU, and I'm happy to be educated, but I think it's very difficult to put law enforcement officers in the position of saying, this is protected constitutional First Amendment behavior, so I should opt out and not record that, and this is not protected, so I can record that. I think it's difficult to draw that line in the field. I think they are used to doing it in the context of law enforcement functions. I don't think that they are adequately or capable of being adequately trained in constitutional jurisprudence to draw that line very effectively. And so from a practical implementation point of view, I would caution against that being an essential element of whatever the other reforms. I think there are ways to balance those interests in other ways by not allowing the disclosure, making a bright line. If there is inappropriate disclosure, obviously if it's clarified in the statute, that would be an act of official misconduct if somebody were to improperly disclose it. And I don't know any officers that are willing to risk their profession, their pension, their livelihood for disclosure, subject to a court order telling them, disclose this because that's what we're requiring you to do.
Thank you. I'm Pat Coughlin. I'm Deputy Chief of Narcotics in the Cook County State's Attorney's Office. I'd like to save some time just by adopting the testimony of Ms. Miller. These 92 pages that was put together, it encompasses all the issues, all the concerns, the 33 recommendations at the end of this report. I can't think of anything that needs to be addressed that isn't touched upon in this policy or in this best practices. With that said, I'd like to jump ahead to some specifics as far as how those concerns should be addressed, as far as who's wearing the devices, how long should the tapes be stored, who has access for your consideration. As far as who can record, recommending uniform officers or officers who have identified their office. If that's done, then there's not an issue. People will quickly know when they're talking to a uniform officer or someone who's identified that their voices can be recorded. And it excludes the surreptitious recording. The state's attorney's office is in favor of allowing police officers to surreptitiously record as well, but then we're talking about one-party consent state, and that's a subject for a different hearing. But as far as this, I think there's no surprise as long as the officer's in uniform or who has identified their office. As far as privacy issue, notification should be given, and that should be a visible notification, whether it be a lapel pin, whether it be a flashing light on the device. I think that's the easiest way to do it. Inside this PERF policy manual, they talk about a public awareness campaign to let the public know that you are going to be recorded. And officers should be able to, as part of controlling a situation or influencing the tone of a conversation, to point out that a camera's, you're being recorded. But I don't think it's necessary to require consent or to require some verbal knowledge that you're being recorded other than just a lapel pin. Otherwise, you will have those conversations where an officer is chasing after somebody, stop, and you're being recorded, or police search warrant, recording in progress. So it's just impractical. What should be recorded? I think it's better to have clear departmental policies with disciplinary action for noncompliance. Cameras should be activated whenever wherever officers are responding to calls for service, which includes all law enforcement encounters. To go back to your consensual encounter, your Terry stop, your probable cause, all of those should be recorded. Because even a consensual encounter, you may be asking for consent to search your car. You may be doing a pat down for weapons, and that stuff should be recorded. Community caretaking is the fourth level, and I think that's the level where it shouldn't be required. Traffic stops, arrests, consent, searches of automobiles, searches of houses as part of a search warrant, interrogations, pursuits, witness interviews. These are all things that, as a prosecutor, we would like to have that best evidence available in court. There should be exemptions for certain encounters when unsafe, impractical, or impossible, or when the witness on camera says, I do not wish to be recorded. And that request should be recorded at least, and to explain why the camera was turned off. The storage of the videos, the footage should not be susceptible to editing, deletion, or unauthorized copying. There's a lot of safeguards that are in these devices that the manufacturers are aware of, and they keep an audit trail. So just as already testified, you can determine when the device is turned on or off. We want to make sure that is the devices that are being used in Illinois. Video should be stored approximately between 60 days to 90 days, unless it's flagged for one of these following reasons. If an arrest is made, whether it's misdemeanor or felony, then those are flagged, and that's going to be part of discovery. And those items should be kept until the case is disposed of or court order. If the incident results in the use of force, those videos should be flagged. If a complaint is filed against an officer within a set period of time, those videos should be recorded, and open investigations should be saved as well. If it's not one of those things, then we're looking at, after 60 days, 90 days, those videos are deleted. Otherwise, it gets cost prohibitive. Otherwise, I think you're going to hear concerns from the ACLU about too much of a collection of video being amassed just on the general public. So there has to be that time frame. As far as access to the videos, officers on the street should not have the ability to edit or delete those videos. They should have the ability to view them. If they're writing the report, to refresh their memory, if it's a frantic scene, if it's a chase, to be able to look at it while they're writing the reports, but they should not have the ability to delete those devices. Supervisors, internal affairs, IPRA, prosecutors, those are the individuals should have the ability to copy those tapes. The costs, we've already heard about the average cost, $800 to $1,200. A lot of the cost is driven by how long you require the departments to keep the tapes, and then how much has to be recorded. You also have to figure in the time that the officers are going to need to flag these videos. So if an officer has an 8-hour shift, no longer is it 8 hours on the street. If they require an hour to go back and flag videos for the first 7 hours of their shift. Some departments, and PERF recommends this, I believe, is having a tablet or having the technology in the squad car, so while the officer's on the street, they can be flagging the incidents. This video has to be saved because it led to an arrest. This was nothing. It doesn't have to be saved. And the biggest issue, I think, is FOIA. You know, I've heard that you need the consent of the person who was on the film. There's going to be a problem with that, determining whose identity for sure is on the film. If somebody shows up at a counter of a police station trying to determine on a person in the background if they're actually depicted, there's going to be problems with a crowd shot. How do you get consent from everyone of that? And I think if the Victims' Right Amendment passes in November, that may implicate the tendering of videos as well. Because if a video captures a domestic violence victim, by instance, tendering that image of the victim, tendering that identity could have implications where you need to go to court and the victim has a right to be present. So the real issue, I think, the major one, is with the FOIA changes. I would urge the legislature to adopt a permissive policy at first. Even though this talks about the pilot programs that were done across the country, they're still ongoing. And we can't say, based on the couple departments that have done this, what the absolute best policy is. We're still learning what the best policy is. One policy is not going to be right for all departments of all different sizes. So I would, for a starting point for the new statute, suggest something along the lines of sworn law enforcement officers may utilize body-worn cameras if the following conditions are met. The recordings are only made by uniformed officers or an officer who has identified their office. The officer can only record from a place where they have a right to be located. They must be in the performance of their duties. Visible notification that a camera is in operation must be displayed. All recordings shall be saved if there's any arrest or seizure made, the incident results in the use of force, if a complaint is filed in a set time frame, and open investigations. Requests for recordings must be made within a certain time frame and must comply with whatever changes or under the FOIA statute is determined to be prudent, and that tapes shall be destroyed within 60 days unless flagged under one of these procedures.
Mr. Chairman, just a couple of wrap-up things with regards to this. This is not the first time, obviously, we have implemented state statute involving video cameras. We've done it just this last year with regards to a bill on psychiatric fitness evaluations, and I want to highlight that one for 1 second. In that, if they do not videotape, if the defense chooses not to videotape the fitness hearing, the expert still gets to testify. It is a factor that the court considers in weighing. And as consistent with what Representative Rebelletti said, I think that's the better approach. We don't want to bar evidence, but clearly juries understand that if you're testifying under circumstances where there is a video that should have been and could have been done and you have no good reason for why it's not there, then juries take that into consideration. We can encourage jury instructions on that, allow for weighing of that. So I think there are some things that we can do other than barring the testimony, as the case that Senator Nolan was talking about with previous panel, that we can do to give comfort that it will be complied with in a reasonable way. We essentially do the same thing with the mandatory videotaping of interrogations. It's similar policies. So that's, I would encourage us to find that balanced approach to allowing the evidence while weighing it appropriately.
And for Senator Nolan's edification, is People v. Gladys, 960 Northeast 2nd, 1104. I just recalled that off the top of my head.
And lastly, if this is addressed through an eavesdropping exemption, provided that we have an eavesdropping law, please, there needs to be some exception, whether it's good faith, because if an officer records something on duty and they're not authorized, it's a Class 4 felony. So make it a good faith exception, make the tape inadmissible if it doesn't comply with it, but don't make it a felony, just because the officer forgot to turn off the tape.
Let me say, I appreciate the clear articulation of recommendations. Not to say that I'm just going to adopt them all, but we really do appreciate that clear articulation of recommendations, because that's why we're here, right? To try to figure out what we're going to do. The other thing I'd just like to mention while I have Mr. Jones here is we appreciate the effort that was put forth this past spring to negotiate what would be the new eavesdropping law with some added exemptions. What I want to make certain that there's an understanding, at least from the perspective of some of us, that we reached a point where we and Representative Rebeletti and I spent some time in the late evening trying to come to an agreement on points, basically all the points, probably except this issue. So it, just so that people can understand, I don't envision reopening negotiations on further exemptions to the eavesdropping law, other than deciding what we do with the issue that we're discussing.
Let me reflect my appreciation to all the legislators involved with that discussion. It was very intensive. The issue of body cameras was discussed at that time, and there was always a willingness on the part of those negotiating to address this issue. There was a sense of urgency to address the eavesdropping piece of necessity as a standalone piece. And then decisions were made not to do that, but to do it in a unified forum. And it's our assumption that we have negotiated whatever expansions we're going to get on eavesdropping separate and apart from implementation issues of body cameras, and that we would not be looking to open up those discussions further. So thank you. On the record, let me say thank you for all of your willingness to work on that. We are of like mind that we're not opening that up again. And to state publicly, perhaps for the first time, it was always the intention of the legislators and, frankly, of us to work to a resolution of the issue with body cameras, because, as we said previously, we are always in the pursuit of the best evidence of what actually happened, and we said at the time the body cameras afford that.
Appreciate that. Mr. Gross.
I'd like to thank you for the opportunity to appear before you today to discuss this really critical issue. The ACLU believes that there's a win-win on both sides of the equation here. We support the use of body cameras in law enforcement. We have long supported the use of cameras in squad cars. In fact, I can recall negotiating a consent decree with Highland Park in a racial profiling systemic case in which we made it part of the consent decree, and indeed Highland Park utilized those in-camera squad cars, those in-car cameras successfully. On the other hand, we also have a statewide policy in terms of freedom of information and access to that information. When those policies are statewide, as they are, then making exceptions to those policies are also statewide exceptions. And so I don't think that this body ought to be considering carte blanche exceptions and allowing the details to be worked out at the lower local level as to what each one of these looks like. If we do not provide statewide guidance on what these kinds of body camera operations ought to be, then we will have abdicated our responsibility to ensure that the statewide guarantees in place are only loosened, are only exempted in very precise ways. And so there are 4 fundamental points that have been discussed over and over again today. And there is a great deal I think, of unanimity. We may be using different language at different times, but I do think that from a civil liberties perspective, we agree with much of what's been said by everyone here today. The 4 areas that this body ought to consider and ensure that they address in any of the exceptions are notice, when to record, the retention of the recordings, and the disclosure of the recordings. In terms of notice of recording, we believe that people should be notified that they are being recorded. There seems to be some consensus around that issue, and we fully support it. At some point in time, no doubt, as suggested by law enforcement here today, there will come a point where people don't actually need that notice should body cameras proliferate and we're become very used to that kind of interaction with law enforcement. But at this point in time, particularly with body cameras that can be small and undetectable, appear on somebody's side of somebody's sunglasses or whatever, I think it's critical that, the public be informed. We probably are comfortable with a lapel pin as suggested by the state's attorneys here today. But something needs to happen to ensure that people are notified that they are being recorded. The next question is when to record. We believe that there is a bright line, and we believe that that bright line ought to simply be that when police officers come in contact with members of the public, that the camera goes on. We think that trying to micromanage this thing is very, very difficult. We think that trying to describe every situation and every permutation of street interaction makes it very, very difficult for a police officer. And there is an inducement, not for most police officers, but some police officers, there's an inducement to stop the camera. I have a case here that we handled in our office initially and then referred out, in which an Illinois State trooper virtually dismantled the car on the highway, took a drill, started drilling through the car, hit a gas tank, had gas pouring out of this car, had this car towed away while a young woman sat in tears. Well, that became a federal case, and that case was settled recently with a non-disclosure agreement with private counsel. But our complaint, her complaint, brought to light the fact that that officer turned off his camera. Now, that was contrary to ISP rules, but that was his motivation. His inclination was to turn off that camera. Now, he was subsequently found to have violated the rules, and he was subsequently sanctioned for that. But we have to recognize that these are not these instances where people shut off the camera. These aren't little isolated instances that happen somewhere else. These aren't stories and anecdotes that can only be found in the perf report. This happens every day on the street, and we have to be mindful of it. And because of that, we need to ensure that once the camera starts rolling, it continues until the end of the contact. And I think the state's attorneys here are certainly supportive of that, but that ought to be a statewide mandate. That's why you cannot let this occur at the local level. Now, there is an instance where we believe there should be an exception to all interactions, and that is for First Amendment activity. Mr. Jones has indicated that he recognizes and is sensitive to the fact that, there are First Amendment concerns. If you walk onto the plaza, the Daily Plaza here, with a bunch of cameras, you are going to deter people from showing up. And you're going to do that at two different levels. You are going to do it on a very immediate level. I may have shown up. It is a public event. I understand that other people are going to see me at this event. But on the other hand, I'm not going to be photographed and it's not going to go viral. The second thing is that taking photographs of people engaged in First Amendment activity chills future First Amendment activity because it allows the building of dossiers, files. Now, I see a little head shaking going on here, but that is precisely what the city of Chicago did for over 40 years.
That's the red squad. That's the spy suit. And sitting here, I've got about 3 or 4 general orders. That decree is no longer in place, but I have 3 or 4 general orders from the Chicago Police Department that are all about First Amendment activity. Police officers in a well-trained agency are receiving instructions on what is and what is not First Amendment activity. Here's the First Amendment in police actions. Here's investigations directed at First Amendment activity. Here's video surveillance technology. Here's in-car video systems. There is I'm not going to talk about implementation, but in terms of training and development of policy, the Chicago Police Department, which clearly is one of the most sophisticated law enforcement agencies in the country, recognizes its obligations to protect First Amendment activity and understands that there is an interface between video cameras and their use and people feeling free to engage in First Amendment activities. And we're happy to discuss how that can be done and how that can be carved out. There's been some concerns about having exceptions for when recording is potentially dangerous, to when there is a complaint from a confidential witness. And those are probably issues that the ACLU can discuss in terms of exceptions to the policy of recording all contacts with the public. But I think that we can all look to the guidance that the legislature has already provided. The agency, the legislature was not reluctant at all in creating its exception, H, in the present eavesdropping statute, in which you require, if there is going to be an exception to the eavesdropping law, that in-camera recordings take place by uniformed police officers who have identified themselves as such, and that those recordings involve, quote, enforcement stops, or when the beacon goes off on top. But enforcement stops are defined. You've limited it. You've described it. I shouldn't say you've limited it. You've suggested what it includes without necessarily excluding other kinds of activities. But they are basically what we're all saying. They are actions by a law enforcement officer in relation to enforcement and investigation duties, including but not limited to traffic stops, pedestrian stops, abandoned vehicles, motorists assist, motor vehicle stops, roadside safety checks, requests for identification, or responses to requests for emergency assistance. That's just about covers the full scope of police activity under enforcement and investigation. So the ACLU is not out on a limb when we're describing as a bright line rule all interactions with the public. What we think is the protection for both the officer and for the public is not in what is captured, but what is released. And so the retention of the recordings ought to be for a very limited period of time. And as the state's attorneys have described, in the certain recordings ought to be flagged. And those involve force, detention or arrest, complaints by citizens, or internal investigations. All other recordings ought to be destroyed after 90 days. The shorter the period of retention, the less likelihood that things will be available to be revealed. But we've given, in 90 days, enough time for a citizen to file a complaint so that that tape gets flagged and it is available for use by citizens themselves. Now, there's some concern about storage of all of these stops. Well, ISP, Illinois State Police, is storing these stops in conformity with the law for 90 days, as is CPD. I have their regulation on their in-car cameras here as well. ISP, Illinois State Police, between 2004 and 2013 had 300,000 to 500,000 stops, and they're storing those. So you can see that the storage capabilities, while they are unquestionably an issue of cost, are not insurmountable. The Chicago Police Department, for example, everybody has agreed here that calls for service ought to be part of what is properly recorded and maintained. The city of Chicago already has, I don't know, we should be, I have had occasion recently to depose some of the record keepers at both the Office of Emergency Management as well as CPD, and the computerized system of activity by police officers, including stops, including arrests, both Terry stops and arrests, is massive and being properly maintained as far as we can tell. The Chicago Police Department had 550,000 priority one calls for service last year, to give you an idea about what it is that we're talking about in terms of storage. So there's nothing that prevents the largest police departments, and perhaps there is some centralized agency that ought to help small towns. But as far as the capability of the major law enforcement agencies in our state, ISP and CPD, they are more than capable of doing that. So the next question becomes disclosure. And that, I think, is the amendment of the FOIA Act. And it's where I think there also is agreement. We believe that most of those tapes won't be available because they'll be destroyed within 90 days. We think that where those recordings have been flagged, that's another game. That's police misconduct. That's where there's been an arrest, a detention, use of force, a complaint filed. We think that those files ought to be available for FOIA. And even in those circumstances where someone is, let's say, a police officer winds up inside of somebody's house, while we can appreciate in the first instance that information ought not be available, it will not be available unless there's a complaint of the use of force, a detention or arrest, or a complaint by the citizen within the house itself. That seems to me to be the proper balance, and no one's interest will be compromised. Where there is a use of force inside a house or a wrongful detention or somebody has complained, that is the point, as difficult as it may seem, where police accountability outweighs individual privacy. And that's a difficult calculation for us to make as well, but we think that it is, because that's exactly why we're doing this. We're tracking this because there's police misconduct, there is a desire on the police departments to be transparent and to show that that's not the case in 99 out of 100 instances, or 999 out of 1,000. I really don't care what the equation is. Everyone recognizes that there's a need to document, in some instances, police misconduct. And once that occurs inside of a house, we all have an interest in knowing that. We also believe that there ought to be a periodic reporting of this data as well, so that you can determine if it's working or not working. And what accommodations need to be struck. I won't keep you longer with my direct comments, other than to say that this is something that is very doable. And I think with civil liberties and civil rights organizations all over the city keenly aware of what's in the balance, that we can get a consensus across those groups as well, that cameras can be a win-win for everybody.
Okay, I have a few questions, and then Senator Nola. So I'm going to start on your last point with the FOIA, where you kind of described it as balancing privacy interests against police accountability, and with the mention of excessive force cases. I guess the question I have is, in those instances, the alleged victim oftentimes of the excessive force, let's say this happens in their home, could be one and the same as the person who wants to protect their privacy. So they would have an interest, so perhaps it's FOIA, you make it foiable to that individual, but they may not want to.
Well, you have to figure out how it is that we know about it, first of all. I mean, we're not going to know about it unless the victim tells us, okay? The victim is going to either go to the police department and file a complaint, or the victim is going to go to an attorney. We request the squad videos all the time, by the way. We have ISP video. We have CPD video. So, for years we've been getting these videos. The way that we know that we ought to ask for a video is somebody comes into our office and complains about it. Or in the case in downstate that I described to you about destroying the gas tank of this car, the victim filed a complaint with the police department complaining about the officer. And we've gone through a great deal of litigation. I'm sure you're all aware about whether or not those files are subject to FOIA, what information you can get about police misconduct. But once the complaint is filed, and we're aware of it, that's how we know to ask for the tape. And at that point in time, I think that the victim will have themselves gone public. And that's how we know it exists.
Yeah, but they may want to go public with certain things, but they may not want, I mean, somebody busts in their house and they're naked and their family is, and there's some certain aspects of their home they don't want exposed. And
I would say that redaction ought to occur in that case. That certainly, it's a simple thing, and PERF talks about this in the PERF report. You can certainly redact the tape.
So
you can blur a face, you can blur a body. Nobody has to be shown nude. That's a very, very simple proposition, and that easily can be put into the FOIA thing. The FOIA exemption can be limited in those instances where there's nudity or there's extended privacy interest. But the FOIA itself today has exemptions for producing materials in which there's an invasion of privacy. The FOIA Act today includes exemptions for confidential sources. That was another concern that people had. So it's not as though the legislature has been unmindful of these interests and hasn't addressed them. Now, we can do it more specifically, or we encourage you to do it more specifically. And I'm not saying that your question is ill put or unreasonable. It is a dilemma. And I would say that we have decided that the interest in ensuring accountability of police does outweigh the interest that someone may have in the fact that they got beaten up in their home. Now, I think that there are a lot of things that we can do in order to protect people, and we could even blur the face of somebody. But most of the time, this video is going to be released at the request of the victim. That's how it works for us. I'm not exactly sure what's happened nationally and why some things go viral and don't, but I would put my money on a plaintiff's lawyer somewhere who got the tape and decided to put it on for whatever reason. But the victim probably is the person who initially got the tape.
I'm going to let Matt comment on this, but you covered one of my questions with the confidential informant protection. I was joking with my counsel here about our age difference. I was going to ask a Starsky and Hutch Huggy Bear or a Beretta Rooster question, and she had no idea what I was talking about.
I don't know what to say.
Matt, you wanted to say something?
Yeah, I certainly agree that a balance needs to be drawn there. I just don't think FOIA is the right remedy to do that, particularly as it's been interpreted and enforced. It's been very broad, including cases where it's happened during pending cases where you could not allege with particularity that it would actually impact the prosecution of the case. Defendants have rights to not have their case tried before they walk into court, something that we actually are very mindful of in this day and age. I think all of the things, or 90% of the things that the ACLU, Mr. Gross, are interested in could be done through other legal means. File a subpoena to get a protective order for the video. In that case, the victim who wants to make the allegation has control over it. I would also say I'm not sure how many law enforcement officials are skilled to do the redaction. I know there's software that can do it, that can blur this stuff. I don't know that that's as easy a task as maybe has been represented, and maybe they don't blur out as much as the victim would want them to blur out. So if you empower the victim, who is also the complaining witness in an unjustifiable use of force case, they can file a subpoena pursuant to their own complaint. They can get the ACLU to file a subpoena for them. You get that record, you preserve that record, but you don't open up the can of worms that the local news media or the local blogger, simply because somebody's filed a complaint, gets to get that and put that up on the web. So I think we can accomplish 90% of what the ACLU wants to do simply by letting the court process through subpoenas and protective orders address it, rather than letting there be an exemption through FOIA.
There was a mention of First Amendment activity. I think there was a little bit of a conflict
Slight.
there.
With regards to that, and I clearly understand their point of view in terms of the chilling. I guess I don't view it in the same way, because you've got everybody with the cell phone now can record it, and whether it's law enforcement activity or somebody else, you know, everything gets recorded and put it on YouTube, whether it's law enforcement or not. So I think that expectation of privacy is diminished. In terms of the red squads and everything else, I absolutely understand that. I think the answer there is retention. You can't really build a dossier on 90 days worth of stuff in the same way that creating a 40 years worth of individual dossiers, you know, secret files, J. Edgar Hoover kind of stuff would allow you to do. So I get their concern, and there is this happens in a context and a history, but that's why we think that the retention period and the non-disclosure are so critical. If after 90 days you can't point to a case or one of the exemptions for destruction, then it ought to go away. So again, that's not a 100% solution from the point of view of the ACLU. I'd say it's, if not a 90% solution, it's a significant solution to the problem simply by getting rid of it. You can't maintain secret files if you can't maintain them.
And Senator, just on, I'm sorry, on the First Amendment issue, not to diminish at all the First Amendment right to assembly, but the police have an interest in, well, in those situations because of the likelihood of a lawsuit if those First Amendment rights are infringed, to be able to record accurately the orders to disperse, the orders to keep moving, the orders to, you know, you're not on the accepted route. They have an interest in recording the provocations that may exist that cause them to make arrests. So the general peaceful First Amendment protest, obviously that favors the ACLU, but there are certain times when the police have to take action, when they have to give orders, and that should be memorialized.
Well, what we're talking about here is chill. So whether the file is destroyed within 90 days or not doesn't dispel the chill. What happens is that the fear that you're going to be recorded and documented and a dossier compiled is what is the injury. And that occurs today. I was the lead representative for the ACLU as a legal observer during the NATO events, and we had just won. Alvarez had just come down, I think, and CPD had changed their position on cameras. And CPD was out in masse with cameras. And to say that it didn't have a chilling effect on people would be a gross understatement. It was a little bit of a circus out there with cameras flying in both directions. But there is a difference between individuals taking films and government taking films. And we think that you should be sensitive to that as well.
Yeah, I mean, I suppose this is a challenging one, because I suppose, you know, for the walker by that, you know, maybe not be engaged in whatever the activity is, I'm a lot more sensitive to that individual than somebody who's made the decision. I mean, you kind of, and I understand there's a difference between government recording and taking photos and one of the local news stations or just an individual. I guess I have to think about it because you're out in public. You're necessarily calling your attention to yourself.
Yeah, you are. You know, I agree with you, Senator. I think that to see the dynamic on the street sensitizes one to this. I think I would invite anybody to attend one of the mass demonstrations that we have in the city from time to time and see, excuse me.
I've been to a few.
I didn't want to call you out. Excuse me, find out your interests or affiliations in terms of your support for political causes, but we have an exception in the what we've formulated in terms of First Amendment activity is you can record it if there's reasonable suspicion of criminal activity. So the concern that was articulated by the state's attorney about when a demonstration goes bad would be easily covered by a camera on the scene, and CPD certainly has cameras on the scene. The question is when you turn them on. But my other point was that there's different levels of commitment that people have when they come out to demonstration. There's the casual observer that you're kind of describing. And that person has no anticipation that they're going to be photographed, known, seen, or identified. If you combine those photographs with facial recognition, and that happens right now in the state of Illinois. I'm sure that these gentlemen have much more experience with it than me, but you're basically matching up against the state database on licenses where they have all of our pictures. You're matching up picture to picture. So if you take a photograph of somebody on the mall, you can go through these databases and you can identify that person. Then you can destroy that film. The film is gone. But you now know who was there doing what. Whether they were protesting President Obama's policies, as people during NATO did, or whether they are casual observers who just happen to be at the event. So there is a demonstrable harm, and we do have this technology that can identify all of us if we have a driver's license.
You want to say on this issue?
Yeah. First of all, if they're doing that on a regular basis, that would be news to me, in all honesty, because I've been told when we've wanted to use the photographs from Secretary of State's office for other law enforcement purposes, not facial recognition identification, but say for lineup procedures, I've been told that there are prohibitions and we can't use that. So I'm sure there's a Homeland Security context where that's happening, but I don't think that's routinely happening. If it is, I guess I'd be interested in knowing that too. With regards to the broader issue of reasonable suspicion, you can turn it on. Again, I come back to a pragmatic, practical question, and I'll give a specific, limited knowledge about a specific fact pattern. That was Ferguson. The protests were lawful as long as they were walking. When they ceased to be walking, they ceased to be lawful. So if you are a law enforcement officer and you are observing those protests, you have to make the constitutional analysis that as long as they are in conformance with the stated reasonable regulation, time, place, and manner, and they are walking and therefore not blocking the streets, then I cannot record. But if I have reasonable suspicion to think that they are going to stop or engage in some other activity, I can turn it on. I think that's I think that is unlikely to be uniformly applied in a way that we all would think would make sense. I think they'll either be over-inclusive or under-inclusive, and I don't know that that serves anybody's interest. I just don't see law enforcement officers on the street, as well-trained as they may be, in figuring out the nuances of that. A protest that appears to be good except that they don't have the right permit? At what point do they know that they don't have the right permit and therefore can't be protesting and they disperse them? Do they turn it on contemporaneous with finding that out? Again, I get the concept, I understand the chilling effect, but for cops on the street, there ought to be a way for them to understand what it is they're supposed to be doing and when. And I just don't know that the First Amendment context lends itself to that. I'd be happy to be wrong about that.
Okay, I just got two more questions, Senator Nola. One, I was listening to testimony of several people earlier about the officers' access and use to the video, and if you think about this in the context of accountability, and I forgot who testified about how what an officer sees and what a camera sees are two different things. So officers reacting to circumstance and on the basis of what he sees, and would write a report based upon that reaction, right? Then he accesses the video and sees something inconsistent with that, and revises the report to be consistent with what the camera recorded. Is there a concern there?
It's addressed in the PERF policy, this issue, whether or not you give an officer the chance to view the video before writing a report. And specifically, it comes up in a shooting incident. And I believe the PERF recommendation was during those encounters, the officer obviously is acting very quickly, heat of the moment, that it would be beneficial to allow them to see a recording of the actual event when things have calmed down. Not that to influence the report writing, but this is just another means of accurately recording what the events happened. But I know there is a concern that the officer could curtail reports or say this happened outside of the view of the camera, but I guess they could do that whether they watch it or not. But at least allowing them to view the video does allow them to refresh the encounter for those very tense situations. So that was what PERF's recommendation was, to allow them access.
You understand the concern. I'm just talking about the rare bad actor, right? When we talk about racial profiling, for instance, we talk about, okay, what was your perception when you made the stop, not what the actual race of the individual is, right? And so, the same instance, if an officer's acting based upon a certain perception, not based upon what the camera actually recorded, shouldn't be that, particularly if there's a shooting or something like that, shouldn't that be what's recorded, or does the officer get the opportunity to
Two things.
change?
Yeah, and I absolutely appreciate the question, because do you want to give the officer to rehabilitate his own initial thought process? I think this is a classic balancing. I think on the one hand, the videotape itself is the best reflection of what a reasonable man would say happened. I don't think you're going to get instances where a person, an officer, is going to, where the videotape is better than what their initial reaction, their perception is going to be. It's almost always going to be less in their favor than what their own subjective point of view would be. And so I think it would allow for a greater degree of critical analysis of their decision if you can see the discrepancies. On the other hand, I think if they write to what the video saw, if you're going to balance those two, I think the video still gives the public the best chance to see what did they see and their own subjective point of view. Was that decision reasonable based upon what I'm seeing? I guess what I'm saying is I think that there is deficiencies either which way you do it. I think you have to pick which way you want the deficiencies to go, and I think saying that they can review their video as they write it, the benefits of that outweigh the potential harms to that, as opposed to the other way.
And if things are, written in a report that are not on video, I mean, we tell officers all the time, prepping them, if it's not in the report, it didn't happen.
Right.
So don't come up with new information, a month later at trial that's not in the report. The same, well, this happened off camera and you couldn't hear it. It's going to be viewed, it goes to the weight of the evidence. And I think it's the video is going to be the best evidence.
If you decide to weigh it the other way and say that ignore the perf recommendations in this and say you can't see the video until after you write your initial report, I think that's a legitimate policy position to take. I've articulated a reason why I probably wouldn't go that way, but I do think that that's a balanced judgment.
Couldn't you have both? Couldn't you have both? Because you use the term initial report, right?
Sure.
So initial report should be based upon, the officer's perceptions
and then the amended report after reviewing the video, this is what I observed that was different than my initial perception. Yeah, I think those are all things that could be accepted. Again, the video we think is the best evidence, and so therefore saying officers cannot refer to that seems to undermine getting it right.
But it all depends on what the goal of getting it right is, right?
The most accurate perspective of what exactly happened.
Because there are multiple concerns. There's the concern of, okay, let's make sure that we record what actually happened for the purposes of having a successful prosecution of the individual, and then there could be in some cases a concern of whether there was excessive force or that
Right. I won't trot out my saw about the unique role prosecutors play. I'll save that for another day. But I understand your point, and I agree with you that the goal should always be to get to the most accurate answer, and right should be determined by what is the most accurate, not necessarily the most successful for securing a prosecution.
Do you have an opinion on this? And then finally, on the question of notice, this hot pursuit, you're chasing a perpetrator,
I think you can have an exception for extraordinary circumstances.
All right. Senator Nolan.
Thank you, Mr. Chairman. And I want to commend the chair and both chairs for convening this hearing and all of the testimony that's been provided today. I think we've accomplished an awful lot, and I have to tell you, the takeaway for me is that we are a lot closer in agreement, I think from all sides, on what ought to be perhaps the new norm regarding whether we're talking about body cameras per se or we're talking about eavesdropping, generally speaking, particularly with regard to disclosure, retention, notice, and your statement that the exception for the eavesdropping statute should be that a uniformed officer, either it's a uniformed officer or an officer that has disclosed his or her office, was attempted back in 2012. Unfortunately, we didn't get so far with that, but it's something that I think is now going to find its way, at least if not by way of an exception to whatever may be the new eavesdropping statute, or left to lie, and it will become the norm one way or the other. The one thing that I'm not sensing agreement on, and I want clarification because I'm not sure that you actually disagree, but I want a clarification in my mind so I understand, because I'm kind of a dog with a bone here on this. I am on a number of issues, I suppose, but this whole issue of the missing video presumption, right? We talked about this before, and the admissibility of testimony that's contradicted by two opposing parties, one of the people, a police officer, and the accused, right? So I know how the state feels, or I know how the state's attorneys feel, and that they would like the jury to decide this matter. The ACLU, I don't know that you have a position on this, but your initial take on whether or not testimony that could have otherwise been, you know, I'm hearing, you know, video that should be, or that must be, should be flagged, you know, and I'm hearing the term, of course, best evidence. You know, what should be the consequences to not providing that best evidence when it could be obtainable?
Well, the ACLU does not have a policy position on that matter.
Fair enough. My question's been answered.
Representative Rebelletti.
Thank you, Senator. We were talking about this whole idea, and Senator Raul touched on it, about reviewing video and then writing reports. What's the standard practice that police officers do right now for DUI cases? Because that's probably as close as we have now to something that would be similar. So I'm sure officers probably review the videotape before they write the report. Some probably don't, which also causes issues because, as we are taught, that police reports are supposed to have not every word in them, but of all the major findings. So what is the sense that you feel from the officers of what they're doing? And if we have to bring back our officer expert, we could do that as well.
Yeah, my sense, my informed sense is that they do review the videotapes. They talk to their partner. They, you know, review the facts before they sit down to actually write the report. So my guess is they probably are reviewing it to the degree they're able to in advance.
And with respect to notice, because I think this is going to be a big issue as well, just like we had notice issues with concealed carry, does the police officer who is stopping somebody for a DUI or for speeding and that video camera goes on, does that officer have to announce to the driver that you are now being recorded and then proceed with the traffic stop?
I think our recommendation, right now, there's no, for a dash cam, there's no requirement for notification.
So they don't have to notify them that there's a video being recorded. They don't have to notify them that there's audio being recorded. And see, that's what I'm trying to look at, using the DUI as a model, because at some point, and I don't know, there was this discussion about having some type of pin or lapel pin that says this is a video device, you're being recorded. I don't know how necessary that's going to be. Is a uniformed officer enough that we should make the presumption that the person could be taping or not? I mean, that's where I guess that's where we're gonna have to go. So I don't know. That's why I'm using the DUI stuff right now. Is we're not notifying the traffic stop that we're recording them. So you have some thoughts on that?
The only thing as far as notification is that the elevating both sides of the encounter. Police officers, when that lapel pin is being displayed, when that flashing red light's going on, or if they verbally say, as in one instance, a person ran up to a traffic stop and pulled out the phone saying, "I'm recording you," and the officer said, "That's great, I'm recording you too." You need to convey, you know, some knowledge, whether it's just through the media, whether through a publicity campaign, whether it's a lapel pin, in order to get, you know, not only the officers, obviously they're going to be aware, and the studies from Rinaldo and across the country indicate that their behavior has changed based on that awareness. There has to be a way to at least notify the other side of the equation in that encounter that you're being recorded, because that knowledge will change your behavior. It makes you more susceptible to following rules.
And just to add on to that, I don't think that this is the only instance where we require some degree of notice of a police officer being a police officer. I mean, how many search warrants have you gone on, and, you know, you get if they're a uniformed officer, fine, but if they're not, then they put on the jacket with police in 4-inch letters and whatever the rules they've got there are. So it is not an absolutely unheard of idea that a member of the public would have to be on particularized notice under particular circumstance that this is a police action as opposed to just some other interaction.
Right, and sometimes the only notice we give people is when we pass a law and it goes into the Illinois Vehicle Code. Now this year, this is a speeding as a misdemeanor versus last year it wasn't. So we assume that that is sufficient notice. The other issue I have is about warrants, which, because as you stated earlier in your testimony about this search warrant police, oh, and by the way, I'm video and audio recording you, because you have situations of no-knock warrants where I've actually been along on those. And so you know, the package is delivered, the bell goes off, or in that case, my case that I'm dealing with, it didn't go off. So the officers are counting. I remember asking them in their testimony, did you count one Mississippi, did you count 1,000, or did you count one, as you're counting, waiting to go in? And then before you go in, not announcing, do you have to announce once you enter the threshold? So maybe, Matt, if you could help me with that as well.
I think that's pretty easy to address, quite frankly, because you're getting judicial action to get the no-knock warrant in the first place. You simply have court-authorized authority to record. I don't know that you need consent any more than you need consent to go in from a Fourth Amendment perspective into somebody's house. You do the knock, you do the announce, go in. I think that's all addressed very easily by changing the search warrant to say search warrant and recording. The need for clarity of this is in circumstance where you don't have judicial oversight in some way, or one other exemption to the eavesdropping statute.
Right. So we're talking more about the notice when it goes from casual contact at Grant Park to it's a nice day out. So all of a sudden you notice that the person has an off-white rock-like substance hanging out of their pocket. So is that what we're talking about the notice then? Is that where we are thinking about it, or at least from the ACLU perspective, what is your thought on notice and when that you'd have to say?
We think when the contact starts, they ought to say that they're recording. I mean, I think that that Matt gave an excellent example of the escalation from a community caretaking function that suddenly goes to whatever it is. Well, you know, I mean, what we really want, and what I think everybody wants, is the recording before that. That's always what it's about, right? What was it that escalated the contact? So the simple thing for the police officer is the bright line. I went over to talk to the guy. I turned on my camera.
And one last question. There was discussion, I think, from either Chief Hayes or one of the other law enforcement panel about permissive use first and then pilot programs. What are your thoughts on that? I know we've done that with lineups, where Joliet was one of the cities, and we use other smaller cities, larger cities to try to do that. Is that something we should look at before full-blown everybody go out and learn this and go from there?
Well, I think because we don't have the funding right now for all the departments to implement it, and because we have some guidance on what the best policy is, but those are going to be actually developed over the next couple of years as more and more Illinois departments put this into place. Permissive to begin with, but if in the enacting legislation it says by 2020 all patrol departments shall equip officers with recording devices, and it's a shall at the back end, giving enough time to implement it, I think everyone sees that's where it's going. You know, especially when it becomes more and more common, because then the defense attorney arguments become more and more compelling. Why wasn't this recorded? Everyone else on your department has a camera. You recorded it earlier in the evening. This incident wasn't. At a certain point, the departments are going to do it. But I don't see a problem, and I think that, you know, that's something the legislature can do, is put that end date where it changes from permissive to shall, because otherwise you're going to have departments who are just dragging their feet and are not going to be moving as quickly as they should.
The only thing I'd say, just to dovetail on that, is with Jahan Gordon's, Representative Gordon's, and Senator Haynes' legislation that would create a funding mechanism, you know, the Law Enforcement Training Standards Board, all the law enforcement community supporting that, there will be a fund that will pay for that. And so I think there's a thoughtful way to implement this over time so that you target it at the areas that need it the most first. That may be based on population, may be based on geography, whatever else. But I agree that permissive for everybody initially is good, and I do think that uniformity, whether mandated or not, will be the rule, and so therefore I don't see a huge distinction between a phased-in mandatory process, unless you guys have a big pile of cash or suddenly can implement this and roll it out all at once. That would alleviate those concerns. But barring that, I think a phased-in mandate it would make sense. And I would conclude by saying uniformity across departments is preferable.
Anything else, Counselor?
No, I have nothing.
Thank you, guys. We've learned that there are some individuals in the state with big piles of cash, but you know, unfortunately, it's Senator Nolan has a follow-up question.
Very quickly. So I don't do an awful lot of DUI work, so I'm going to express my ignorance if I haven't already. Tell us what has happened with the fact that it's my understanding that largely absent video corroboration of the officer's observations of an individual pulled over for DUI, that those cases are dismissed? No?
I think that's sort of a regional perspective. I can tell you in a lot of places we're still doing DUIs without the video. It is absolutely harder, kind of like the CSI effect. People expect it and they want to know when it's not there, and defense attorneys always raise the issue. But there are successful prosecutions without video. I think in some jurisdictions it is the policy not to do it. I can tell you that is not, I would not say that that's a statewide policy that I would share.
I don't think that there's a Cook County policy not to proceed if the video is not working, because I know that there's prosecutors in the traffic division that know that if the officer's assigned to this squad car, that the camera doesn't work. And even judges know that because it's the same.
Well, that's a little bit different. I understand
but they still proceed. It's just a harder case to prove, and that evidence is lacking, and it does influence the trier of fact, in my opinion.
Very good. Thank you.
All right, well, thank you. I think this last panel was a critical one, because I think we've gotten some recommendations and we've gotten some indication that we're, I think, closer than a lot of people may perceive. I do appreciate both of you coming forth with some specific policies that can be statewide policies, because the sense that we were getting on panels earlier is that just make it permissive and leave it to local. And I think there are certain things that we should do that with, to be clear. But I think there are some things where the state ought to take a stance on statewide policy. Given that, the Joint Committee, House Senate Judiciary Committee is adjourned.
Thank you.